8. And I have to apologize to both parties because I read the order wrong. He wasn't appointed an attorney to represent him. He was afforded other accommodations. And he was supposed to be bringing those to the court. I see that I sent it over from the 22nd to today. And nothing has been filed in the meantime. So I guess based on that, I don't see any reason to not enter the order that's been presented to sell the business.
Your Honor?
Yes.
I did, as you instructed, got a hold of the court administrator, and they did, although it didn't say on my original GR 33 about an attorney, I wasn't aware that I could actually be assigned an attorney or a GAL when I originally applied for that, or I definitely would have. The court administrator helped me get the right forms. I did then go to the attorney that is at the courthouse that helps you fill out the paperwork. I did that. Then I returned it to the court administrator. They presented it to Judge Basher, and he did approve my request, the GR 33 for an attorney. And so then the court informed me that the administrator called me on Friday, said it's been approved. And then, of course, we had the holiday weekend. So I haven't yet been assigned an attorney, but they did file it. They said that you would have it before this hearing. I do have the order here from Judge Basher. I
do see that order. It doesn't say what was granted, so I don't have the motion requesting GR 33, so I don't know what accommodations were granted.
Yeah,
hold on, Mr. Couch. Hold on, Mr. Couch.
Okay.
Ms. Terry, would there be a reason why, and I don't know, I thought those were usually filed under seal, but they may not be, and the request for GR 33, those don't get filed, is that correct?
I do not believe so.
Okay. All right, how much time do you need to get an attorney?
I'm not sure how long that takes, Your Honor.
So
you have an idea?
Administration didn't give you any. I don't know that. I'm asking if administration.
Okay. They did not give me a time frame per se.
Your Honor, if I may, just briefly.
Several weeks, I would imagine, or at least I would think, to get an attorney on board.
And Your Honor, I would just like to remind the court, I originally filed this motion to sell.
I understand, Ms. Ward. I know. Go ahead and make your record. I don't think there's anything the court can do at this point, though, however.
Is there a way of finding out what exactly happened? Because there has been it's one delay after the other. This was originally filed on June 22nd. He has had months to obtain an attorney. For the last year, he's been coming to court consistently saying he's going to get an attorney. It has been one delay after another. This request is extremely time sensitive. Just since this motion's been filed, we're coming up on, it was filed June 22nd. This is September 5th. Every time we come, there is a new excuse presented for why a set over needs to occur to allow him to respond, to allow him to obtain counsel. I would ask, is there some way to find out what exactly this most recent motion he filed, what relief is requested? Because to set this over yet again, essentially, the house is going to, or the property is going to end up going to foreclosure by default, just because we can't have the matter heard by the court. So I definitely understand trying to make accommodations. It's unclear to me why the relief he would be granted through GR 33 would be any different at this point in time than it was previously. So again, if there's any way to just recall this matter, I'm happy to do some digging to try to figure out what's been going on, to contact the clerk. But we really need this resolved today, because there is a
hold on, Ms. Ward, 1 second.
Understood.
The cousin that I was talking to, that's Stacy's older.
Ms. Flowers, can you please stay muted until your case is called? 21-30039, and they don't file the request, they only file the decision order. And so then
Your Honor, you're not muted.
all right, then court administration is going to bring in the request. They're going to pull up the request, bring it in to me so I can review it. If he was granted an attorney, there's no choice but to afford him a set over, and that's just the way it is. Unfortunately, I do agree with you, Ms. Ward, that Mr. Couch could be just inadvertently causing damage to all parties in this case by the delay. But we're here where we are. And unfortunately, that's the situation we have to deal with it. So we'll recall this case as soon as I get that information and confirm what the request was and what was granted, because it does appear that whatever his request was granted in whole, but I don't know what that request was. So we'll recall this in a moment.
Okay, thank you, Your Honor.
408 on for GAL compliance.
Matter's ready, Judge.
All right, and it's like the GAL was appointed July 18th. Today was the review to make sure that the parties have received their packets, returned their packets, and the payments are starting to be made. So where are we with that?
Your Honor, this is Amy Turnbull on the GAL on that case, and Mr. Svolenka has complied, and I have heard no response from Mrs. Svolenka. I have mailed, texted, called, emailed several times. She was incarcerated last week, but I've had no response from her whatsoever.
Petitioner in this case is 90%. So you're only missing out on 10% of fees there.
That's right.
So the vast majority has been paid at this point. Any other, and I'm assuming, I guess, Mr. Zandi, have you received any information from the respondent in this case?
We haven't, Judge. This is the case where there is a unfortunately deep history of substance abuse. My client understood that his wife relocated to North Carolina some time ago, and I still have the pending criminal charges. My best guess is there may be a warrant, which may be a warrant status. We have not heard from her since just after the onset of the temporary orders back in the spring. And frankly, this is information that Ms. Turnbull gave me last week, and that was an update on my client a week and a half ago or so, and that was the latest information I had. But yeah, I think we're just kind of in limbo awaiting Ms. Svolenka's decision whether she can participate or not. My suggestion would be we forge ahead. If it's a one-sided report, it is what it is. I think the court made it clear to Ms. Svolenka that she was to participate. And at this point, it doesn't appear that she's willing to do so.
All right. And I guess one last question, Ms. Turnbull, was she in custody locally or somewhere else last week?
Charlotte County Jail.
Okay. All right. I would agree at this point. I think, Ms. Turnbull, I'd ask you to just forge ahead that 10%. I'll reserve that we can potentially make that into county pay if it becomes an issue, but I'd ask that you just move forward with the report. And Mr. Zandi, I guess just status quo, but Ms. Turnbull, just go ahead and start your investigation with the information that you have at this point.
We'll do that.
Very well. Thank you, Your Honor.
I'm here.
Thank you.
So it appears we will be ready for trial. I do have conflicting days on that week, but we can take this up at the readiness hearing. But it should only take a half a day because these issues are narrowed quite a bit.
All right. And Ms. Moyer, you agree that a half day is sufficient?
Yes.
Okay. Well, if there's, and are you thinking you have issues, Ms. Cotto, week of, like which day it goes week of, or?
Yeah, I don't know.
Okay.
I've got 3 trials scheduled that week. I have no idea what's going to happen.
Well, then, we are set for readiness on the 19th. That's an 11:30 hearing, and just be advised that that is a Zoom hearing. And you can get the link on the Superior Court Administration webpage.
Okay.
So September 19th, 2023, 11:30, that'll give you the exact date, the week of the 25th, that your trial will be heard.
Okay.
All right.
Thank you.
008. So there was a request for accommodation, including court-appointed counsel, and that was granted. I understand the timeliness issue that we are dealing with in this case, but at this point, I don't have I don't think the court has a choice. I'm going to set this to the 26th of September at 1:00 p.m. Mr. Couch, you need to make sure that you reach out to Superior Court Administration and continue to do so regularly until you get that attorney. Make sure you meet with them as quickly as possible. It is a time-sensitive matter. I don't anticipate giving you a whole bunch more time. So please make sure that your attorney is aware that they need to get up to date and be able to respond to this relatively quickly. Okay. So we'll see everyone back on the 26th of September at 1:00 p.m. Blowers or blowers, Mr. Ian?
Thank you.
Flowers.
Flowers. Okay.
Yes.
I think I said it right once.
Yeah.
My apologies. All right. We are reviewing the temporary and emergent orders that were entered last week. I did just receive an immediate temporary order granting other relief. I have not had a chance to review this,
Right.
but Mr. Ignacio, if you want to tell me where we're at.
Mr. Blowers, Gary Blowers, has not vacated the home. You gave him 48 hours, and we've had that plus a long weekend, and he still has not vacated the home. So I'm asking for basically an ex parte order, just clarifying that she has immediate possession of the home. You granted a restraining order, and my understanding, the Longview Police Department is attempting to serve that, and he hasn't been able to get served yet, but he'll get served with a restraining order and this order, and then she can take possession of the home and try to get it out of foreclosure before the home is lost. So it's an ex parte request that Your Honor basically clarify last week's order, giving him 48 hours. We're beyond that it's now he's immediately to be out, and then we can enforce that.
All right. And I just want to say, is there a Gary Blowers present? *6 to unmute if you're on a telephone. I have nobody in the waiting room. All right. Not hearing a response. I have reviewed the order, and the only thing I changed to it is under number 1. I said possession of the family home awarded to her on a temporary basis.
Oh, sure.
Is just because obviously we're still in the midst of determining final orders. And I will sign that order and get it to the clerks as soon as we're done.
I appreciate that. Thank you, Your Honor.
All right, thank you. It's on for presentation of orders. I don't know. I don't have any orders in the file other than the original orders from July that were provided by the petitioner. So I don't know. Mr. Gross, were there any agreed orders?
No, Your Honor, and I thought we were just back here for a review because the presentation the first time around was missing so many factors. With petitioner and I have exchanged some emails, and she clarified some things for me. It does appear that the child is admitted into the college. We've got a statement of expenses, but not a bill from the college yet. So I can look at the proposed orders that petitioner sent over, but we haven't had a chance to review those yet. I thought this was just a review of that matter because it was not fit for the hearing yet last time.
Well, as long as it's moving towards some resolution and there's an agreement to, I believe the parties were, or your client specifically was in agreement that he would pay his portion of post-secondary support with some additional information about information we didn't have last time. So
We do need guidance from the court on two things, Your Honor.
sure.
Petitioner's asking for my client to pay support for a quarter that the child's not enrolled in school. I submit that's not appropriate under the statute. And we are asking that the court order that the payment for post-secondary education support be divided in thirds, 1/3 for the child and 1/3 for each of the parents. if the court can clarify that for us, we can prepare the orders or modify the ones petitioner provided.
Okay, and which quarter is she not currently enrolled? Is she taking a quarter off in the winter or fall or spring?
Summer, next summer. So petitioner can clarify for me if I'm wrong, but my understanding is she's enrolling in the fall and will be fall, winter, spring, and then not next summer.
Right, is that correct?
So she would need to take summer term off if she's expected to pay a third and to cover her own living expenses or any pieces of those, because she'll need time to work. She's taking a pretty heavy load. If she will work summer, if that's, she will go to school summer if that's what it takes. But we were asking that the living expenses, because I sent over, my understanding from what you said before is that we were supposed to negotiate a dollar amount and come back, that he seemed like he was willing. I sent over the college expenses where it shows tuition fees, books and materials, living expenses, transportation, miscellaneous, etc. All of those expenses are things that the college expects to be college, during college. Those are the expenses, and that's what I thought we were looking at. So that is what I suggested to him. And I broke it out with thirds and put it by a month. And I prefer that we would pay by proportional share. Our incomes are extremely different. And then we also had talked about the potential of looking at this number and then reviewing the amount paid for child support for the one child that is still getting child support, which I'm prepared to go over this. I just wasn't prepared previously. I didn't have counsel. I have talked to an attorney, and she said that it would normally be by proportional share. Unfortunately, that attorney was unable to work with me because she does not work in Longview. And so she gave me the name of somebody else. And if it's necessary for me to get representation, that person, I can get on their schedule. Somebody that she suggested. But I thought we were just looking at these numbers, going to determine how we're going to split that, and then review the amount that child support is.
Okay, I think my order from the last hearing, I'm not making changes to the child support for the child that's currently in high school. I don't think there was enough information to change that. So I think that issue is off the table. As far as proportional shares, and I guess Mr. Gross, correct me if I'm wrong, but I'm pretty sure that was what the ruling was last time. There was insignificant difference in what was requested and what was currently ordered. Once you take the other child out of the equation. Okay, hold on one second.
I don't think the court ordered anything last time. There was a lot of discussion about the status of the petition and information missing, but I don't think the court ordered anything at all last time.
Well, I think I declined to change the child support for the underage child.
That, I beg your pardon, that you did. I'm talking about whether or not you ordered proportional share for Raya, the college student.
Right. That I did not discuss. I did. So I see currently the child support worksheet that was entered as a final order in April of 2021 has 16% petitioner, 83% respondent as proportional share.
That's correct, Your Honor.
Do I get another turn after you? I don't understand how this works. I'm so sorry.
What do you want to say, ma'am?
It's totally fine that there's not any changes, because originally I had not asked for that, but Joe actually had put in the different dollar amount for the one person, which is what I thought he wanted. So I did change it. And I wasn't sure what constitutes significant difference, but my gross monthly income is $1,000 more than it was before, which is a third of what was imputed to me. I mean, like, it's considerably more, which is fine. If you guys don't want to change that, it's totally fine. But his income has also gone up by $1,000. So I'm not sure what constitutes significant. But that's okay too. But I just was curious about that piece. And then if there was enough information there, because I did have the student enrolled in the school, and I did show the financials And what I had put in here on these other pieces were merely things to show that it's been difficult to negotiate with Mr. Lynch. In fact, at one point, Raya could not go to the chiropractor for what she needed to do. I mean, the child has, she was recently diagnosed with Tourette's and some depression and potentially some other autistic issues, but it needs more looking at. And it took over a year to get that appointment, to get her in, to get her actually even assessed. And so she's working through that as well as going to school. So
Is that the older child or the younger child?
that is the older child.
Okay.
Yeah. And at one point, Mr. Lynch didn't pay her doctor bill, so I couldn't get her into the chiropractor, and we had to call back and forth, and finally the chiropractor allowed that. But he finally did pay that, but I'm just saying sometimes it's really difficult to work through. And I did submit this in May, and I was more than willing to work with them. And it's been a significant hardship for her to decide how she's going to move forward. She had the opportunity to move in with a friend, which would be a wonderful thing for her to be able to do, but not knowing what her status was going to be financially has made it significantly difficult. And here we are right before school starts for her on the 18th. And it's kind of been a long process.
Well, Your Honor, we disagree with, of course, a lot of those representations, and they also had nothing to do with the issue of proportional share versus 1/3. The petitioner misstated my client's income. We provided statements and a proposed worksheet of our own for this process. And that shows at this point, the proportional share would be 70% my client, 30% for petitioner. And so if the court was going to order proportional share, I suggest that reflects reality, but we are still requesting it to be 1/3, 1/3, 1/3. Any issues about medical coverage, et cetera, have nothing to do with this particular discussion.
I just meant that it was difficult, that's all. And I apologize if it's not my turn, but I redid the financials. I don't believe that mine were in error. I believe yours were. You actually, if you look at yours versus
Okay, I don't need to hear any more information about that. So here's what I'm going to do. I pay supporting for the quarter not enrolled. I mean, traditionally, kids have summer off when they're in college. In a quarter program, it can vary. I went to a college that had quarters, and the summer was considered essentially a fifth session. So clearly, this is more like this is a little bit different, clearly set up than what I would be used to for a summer and a quarter system. I think that there's support is support. I don't think there's anything wrong with paying, even if she's not attending school during a portion of the summer. I'm going to assign 60% dad, 25% mom, 15% child.
I'm sorry, my computer was cutting out. I didn't catch that.
60% dad, 25% mom, 15% child.
Oh, I'm so sorry. It's cutting out.
I'll email her the court's ruling, Your Honor.
Thank you.
Thank you. Good luck.
Can I ask one more question, please?
Very quickly.
Thank you. The parts that were the extracurriculars or the other pieces that we agreed to, like how medical is paid, is Raya, do we still follow that because she's in school, so we're still paying for her percentages of medical and
that has not changed.
Okay, correct. So that stays the same until she's out of school? Okay, thank you.
Assuming she graduates before she's no longer eligible for medical benefits and all that good stuff.
Okay, and the other pieces that are in those extracurricular parts? Like
I haven't heard anything about that, not making any changes to that at this point.
Okay, so it stays the same?
Yep.
While she's in school. Got it. Thank you.
All right, thank you. Good luck. On for review of the final GAL report. I did receive a copy of that from Mr. Lawrence. Let me see here. Got that at the beginning of the month, or excuse me, beginning of last month. And we were here on the 22nd. It was agreed set over to today's date. I've seen a few declarations filed. What are we doing?
Your Honor, I'm hoping that we can hear from Mr. Lawrence first. I don't know if his mind has been changed on anything given some of the evidence that was submitted to him. I'm hoping that that might kind of lead us to whether or not we need to argue, and if so, who.
Your Honor,
I'm assuming we're talking about the polygraph.
Okay. Yes.
Mr. Lawrence, did you receive that information?
Yes, I have.
Okay.
And I was pleased to see that that there's no evidence that that he was being inappropriate with a child. And he denied any allegations against Jaden as well. And it showed that he was truthful. So I'm pleased to see that. Whether the domestic violence was an issue, Nathan has gotten involved in a treatment program through the counseling firm that Olivia Lovely leads. To my knowledge, he's still in that counseling and attending on a regular basis. And Jaden had expressed some concerns about Nathan's request for a 50-50 visitation schedule. She would want him to complete the domestic violence treatment program. That was my recommendation, and I have not changed my mind on that.
And if I can reply. This is a young man who, they were both young, obviously. They made the decision to have a child at age 14. Neither party has been come at this with clean hands. The violence that we're talking about is 90% verbal. It was abusive on both sides, absolutely. We've heard Snapchats, we've heard all of those things. But the fact is that the mother of this child falsely accused my client of rape, pulling his name through the mud. That has now hopefully been laid to rest through text messages, polygraph, all of these things. My client currently works at my office. You'll see a declaration by my staff from the office manager. He is an incredibly mature child. He is growing faster than probably he should have had to do. It's a stressful environment. He handles himself well. The fact is he has supervised visitation. Miss Edgel has had a problem with marijuana, has had unstable residences. The child's been returned with lice more times than they can count. She has dropped out of school. She has refused to take the child to school for visitation. She was kicked off the bus for failing to do something. In any event, these two are at diametrically opposite positions for where their life is going to go for the future. Jaden is making her choices. My client is making his, and his are really, really good choices at the moment. What my client wants to see is we don't need to go to 50-50 immediately. We can sit through this and wait a little bit longer. But the fact is he needs to have unsupervised visitations. I trust him with my own child, and he has done excellent. And to be frank, I don't know of many 17-year-olds that don't have problems, but he is an incredibly hardworking, honest, even-keeled person. He wants to be a father. He wants to be a man, and everything he's doing is edging in that direction. So I'd ask the court to look at that full record and to look at the fact that, you know, having been falsely accused of rape, he could have freaked out and gone completely the other way. He didn't. He held his tongue. He didn't say anything else to her. I think that shows a level of maturity that you're not going to get in most 17-year-old parents. So we'd ask for visitation to increase by 1 overnight. So 3 overnights, and we can do 3 and then 2 and then 3 and then 2 a week, that it be at school to transfer. And if not school, then the courthouse or somewhere like that where there's going to be cameras. That the parties seem to be getting along at the moment. No, nothing's been said or anything like that, but that they communicate maybe through family wizard or what is it, Mind Talking? There's so many of them, but whatever the court wants to do, but that they be unsupervised. He's been around children. He's been around one crazy little kid, and if anybody's gonna want to harm a child, it would be that one, because he's out of control, and he did it with grace, and he's ready to parent his own child now. So I asked the court to give him a shot. He will stay in DV treatment. And from then on, maybe we can talk about 50-50 once he's completed a block. I think the full year is asking a lot, but even a 6-month block, maybe we start talking about it again there, because my client is in the more stable situations. My client has a very stable house, a stable family. His father is great, wonderful. His mothers take charge. The child will be protected. That's not the question. In Miss Edgel's house, it's a different story. There's a lot of change, a lot of chaos, but my client's not trying to take the child away. He realizes that both parents need to be in that child's life. Thank you.
So just to clarify, Ms. Winkles, so he's currently on supervised visitations. You're suggesting 1 to 2 overnights a week for the next several months, see how that goes, and then address it again. Is that?
Yeah. I thought he was already getting overnights. I thought we were doing weekends already. Is that still happening? Anyone know?
I guess I was looking at the GAL report. I don't know what the last parenting plan indicates here.
So what I was thinking is 3 overnights in 1 week. So Friday to Monday, and then the next week, just, Friday to Sunday. Miss Edgel likes to go out with her friends on the weekend. It makes sense. My client has a job during the week after school at my office. And if he has to work on the weekend, the child is more than able to come to my office with my child as well. So there's no, dad has a strict structure in place. I'm not sure if mom wants weekends and we can think of something else. But my hope would be 3-2.
Okay. Thank you for clarifying that. Ms. Ernest.
Thank you, Your Honor. First of all, I don't think my client has an objection to increasing visitations right now. She's been willing and ready to start moving towards 50-50. Her one request was to finish the domestic violence treatment that Olivia Lovely recommended. We have no objections to the GL recommendations as they are. I will say that the polygraph test to my client feels like another opportunity to litigate an issue from a domestic violence protection order that was found on different evidence than the sexual assault allegations. Ms. Winkle said that my client has a problem with marijuana. That my client did take that hair follicle test immediately after court the last time it was ordered, and it came back negative. And to say that Mr. Walker is the only person that has grown throughout this process is a misstatement. My client has graduated. She's enrolling in LCC in the fall to study counseling, and she continues counseling on her own. Really, my client is ready and willing to start communicating more freely with Mr. Walker. She has no problem communicating on a parenting app. The one request that she has had throughout this process is for him to just finish the DV treatment and have that be a factor before supervision is lifted.
So okay.
And Your Honor, if I might, the DV treatment is mandatory when you have a DV protection order in place. And the crux of that protection order were the allegations of rape. There were also—
That's false. It's false. That's not what the DV protection order was. That was months before the allegations.
The text messages are concerning that in that DV order or in that DV case. And so that's the thing is would he have had 12 months? Who knows? But the fact is he had to have had 12 months because of the DVPO in place, which was not re-upped or anything of that nature. And additionally, the text messages that were supplied much later on from my client showed, I think that GAL will acknowledge this, showed bad actions by both parties, real childish, petty squabbling and abuse and trash talking.
All right. Here's what I don't see, and anybody can point out to me where it is, but I don't see ever there being a completed even temporary parenting plan in place in this case. So what does the current visitation schedule look like?
One moment.
They came to an agreement a few months ago. If you're on hold 1 second, I can grab that.
The plan I believe that they're following right now, I don't think it was submitted with the court, but we do have a draft.
I just received it as well. It's Saturday at 4 p.m. or 10 a.m. till Sunday at 4 p.m. Saturday at 10 to Sunday at 4, and it is an overnight. Okay.
And is that agreed, Ms. Ernest? It's every weekend at this point?
Yes.
Okay. So, and it sounds like, Ms. Ernest, that your client isn't opposed to potentially extending that weekend a day to 2 days.
I would say probably start with a day. I know that she has been up for, like I said, increasing visits toward 50-50. And I know that she wants to communicate directly with Mr. Walker through a parenting app so they can start building trust and continuing to agree on changes.
Is our family wizard agreeable to both parties?
Yes, Your Honor.
Yes, Your Honor.
Okay. All right. Go ahead, Ms. Winkles.
Yes, Your Honor. The one thing that I'll state is, again, Dad's house is the safest place. And really, Mr. Walker has done everything necessary. He's taken parenting classes. He's done evaluations. He's going to treatment. He's jumping through every single hoop to prove himself. He got himself a job. He did all of this on his own, and to still require supervised visitation when there is nothing to supervise. The fact is that you'll read from the polygraph, he's never laid a hand on his daughter. There were allegations made about that. There were allegations made that he was a rapist. That didn't happen either. The entire quote unquote DV is some really toxic, almost what you would hear in video games, trash talking. And it is definitely not right. My client understands that it's childish and ridiculous and has gone through treatment, but to stop him from being able to be alone with this child because of a 14 to 15-year-olds having a relationship and how they talk to each other, it's a lot. So we'd ask that the unsupervised part fall away. He's a good kid.
Right. Any comments, Mr. Ernest, on the supervised, unsupervised portion, since that is a more recent request?
I think I would just say again that we agree with the GAL recommendations to continue supervised visits until the DV treatment is completed. We think that's appropriate given the history of the parties. And I understand that we're sort of relitigating a lot of the domestic violence issues at this point. Both parties have grown a lot, and we're not denying that Mr. Walker has grown, but my client is deferring to the professionals and agreeing with the GAL.
All right. I appreciate that. Thank you. And I don't want to take, obviously this is a case that's, I think Mr. Lawrence and I have been equally frustrated about some of the behaviors and goings on in this case. I do feel like we're at a much better place with these parties now, and I appreciate that. So I don't want to slight anyone in any way with kind of new perspectives on what's going on here. There were some pretty significant allegations that were made, regardless of what the truth behind those, or veracity of those. We're now here where we are. I think Mr. Walker needs to continue to take all of those domestic violence classes. I'm glad that he's doing really well, and that there's a lot of positive things for him. And I know Mom has grown as well. And I think it's a very positive step that they're willing to try to communicate and work these out amongst themselves, because frankly, that's where they're going to be in the long run. They're not going to always have anybody or someone there to mitigate, to mediate, to help. They are young and they're parents now, and that's just kind of the situation that they're in. I am going to order that our family wizard take place. Mr. Walker needs to complete his DV classes. I'm going to order that I'm going to expand his weekends, but I'm going to keep him supervised, and we're going to review this in 3 months. So what I'm going to do is the second and fourth weekends of every month, Thursday after school until Sunday at 4. The first, third, and fifth weekends, Friday after school, whenever the normal exchange would be, Friday evening to Sunday at 4. What I also, though, want to put in there is Mom may have a weekend that there's a plan or some activity happening. This should not preclude Mom with sufficient notice from getting a weekend if there's a birthday, if there's a trip to the beach or something that she has planned or has availability to, that she can get a weekend with sufficient notice, and then Dad would get time during the week with the child in exchange. So I'm leaving it to the attorneys to figure out how to word that, but I think both parties hopefully understand where I am. I think excluding weekends indefinitely from Mom probably isn't fair. If they can communicate and get notice, that should be accommodated, and Dad would just get those either 2 or 3 overnights during the week. Fair?
Yes, Your Honor. I do have a question. Is there a benchmark that we can give my client so that he knows what he needs to do personally in order to have unsupervised visits at the next review in 60 days?
Well, I just continue compliance with everything. Any updates that he wants to provide, if he's, and I don't know when he started his treatment. It was this summer, correct?
Yes, he started it about 5 weeks ago.
Okay. So, an updated compliance report, just how things are going overall. And frankly, if things are going well, Mom may be in agreement with changing that at that point in time. We can either set a review date today. I was thinking actually 3 months. So I was thinking we can look at maybe December 5th actually happens to be a Tuesday.
And
Is
Your
that-
Honor, would you be willing to take testimony from Olivia Lovely, who would know better than all of us about what was going on? Just a brief, if she could be on the record, just briefly to tell how Dad is doing.
Your Honor, I don't believe Olivia is providing his actual counseling. I think it's Sam Case who works for her.
Okay. Or Sam Case then.
Thank you, Mr. Lawrence. I'd prefer something in writing that gives Ms. Ernest notice of what's going on and an opportunity to ask any questions that she may have. But if that individual is willing to be here to answer any questions, I'm not opposed to that.
Okay.
If that's something you want to do and Ms. Ernest has notices and has is able to have a discussion with them beforehand and it's agreed, then I'm fine with that.
Okay.
Okay. So let's set a review for the 5th of September at 1 o'clock.
Or 5th of December.
That's what I meant. December 5, 1 p.m.
Okay. Thank
All
you.
right.
That is ready.
All right. Thank you. Good luck. It is ready, but it's not ready. So this was set over because we were going to have Commissioner Carmi step on to kind of clarify a previous ruling that she made. Additionally, I have now filed a recusal in this case. So I can't hear it. So I don't know how soon we're going to have Commissioner Carmi back. I don't know where you'd like me to set this. I think that there was a disqualification. No, there's no disqualification against Judge Evans. If you want to put this on his 9 a.m. calendar.
Let's set it over to, do we have a commissioner docket currently?
I
On one
know
of those dockets or something?
I'm doing Thursday's pro se docket, so I'd ask not to set it there. I don't know who's doing tomorrow's pro se docket. I can find out here. Because
And is this a recusal or an affidavit against your honor?
it's a recusal. I know your client.
Okay, I
Okay,
see.
so
Okay.
let me put you on mute. I'd prefer to get a date that will work and not have to reset this again. So just hold on.
And I'll tell you too, that this is set to be back in front of Commissioner Carmi, depending on what we were going to do today, to review the protection order in case your honor didn't want to rule on that. And I believe it's next week sometime. I want to say September 11th, but if she's not back by then, I think it leaves us in the same conundrum.
Okay.
I think we are in front of her on the 11th, Your Honor.
Is that in this cause number or a different cause number?
No, it's the protection order cause number.
Okay.
The hope was just to consolidate these into one, which we can still do if it's on a pro se calendar, unless your honor's covering that.
Well, I know I'm covering this Thursday. I don't know about tomorrow morning and I don't know about next week. So let me just pause or put you on mute for 1 second and inquire. Okay. Sorry. Thank you for your patience. My understanding is that Commissioner Carmi will be on next Wednesday's pro se docket. I don't know. And I guess we defer to Miss Terry if we can set up, because that'll be a case that is live streamed, and protection order cases are not live streamed. So I don't know about setting them both at the same time because they're different case types. The clerks generally have to keep them separate. And the second part of that is because protection orders are not live streamed. So I don't know if you want to keep that one on the 11th and set this to the 13th, or if you would like to, what you'd like to do.
I think what Commissioner Carmi was attempting to do was just consolidate everything under the one cause number. This is a case I really don't think needs any kind of live testimony with that. And certainly Ms. Becker can disagree if she wants to. And I think putting everything over to today was kind of the goal with that. She set the 11th hearing just in case we couldn't resolve the protection order issues. I'm neutral on that. I mean, if I certainly understand from the clerk's perspective, if the court wants to set it all and consolidate it, kind of pursuant to Judge Carmi's ruling, that's fine. If you want to parcel these out, that's okay too. But again, finding time and the cost of that is problematic sometimes. I just assume we keep everything together, but.
Right. Ms. Becker, do you have a position?
I'd prefer to just keep it all together. It just saves time.
Okay.
So I think if we do find one of those pro se dockets, that would probably be ideal on either tomorrow or next week. And then we can strike that hearing for the 11th if we can consolidate and do everything at the same time, whether that's in front of Commissioner Carmi or someone else.
All right. Miss Terry, is that something we can do?
Yeah, I think that will be fine.
Do you have the cause number, Mr. Zandy, that's on for Monday, the 11th?
-08.
Okay. Well, if we could strike that from the 11th, set it to next Wednesday, because we won't have Commissioner Carmi tomorrow. And I think that docket may be closed already for tomorrow. So if we could set to I think next Wednesday is the 13th, at 9:00 a.m., this matter and the 23-200-679-08 matter. And that should be Commissioner Carmi. So, she'll be able to pick up where she left off, hopefully on this matter.
Is there someone else that we can see this in front of, or does it have to be in front of Commissioner Cartney?
Well, it doesn't always have to, but part of the issue was this was set over for her to kind of clarify a prior ruling. So that's part of why she needs to see at least some of it. So it doesn't always have to be in front of her, but to at least get that portion done with, I want to make sure that she is able to clarify clarify that prior ruling. And there was some follow-up from that prior ruling that she needs to discuss with you all. So
Okay.
We'll set it to the 13th at 9 a.m.
I know McLean appearing on behalf of the respondent, Kenneth Hansen.
Good afternoon, Your Honor. Jennifer Joslin on behalf of Ms. Hansen, who's present via Zoom.
All right, thank you. All right, so I've seen all the memorandums and read everything that's been submitted. I did, to be honest with everyone, I didn't review every single supplemental declaration by non-parties, just because I have some questions. So, and I don't know that either party answered them in their memorandums of law. So, the relocation has been pending for almost a year with zero movement whatsoever from either party. To me, that isn't grounds to keep a case open and just amend whenever you want. Additionally, these, I guess, a month after the relocation was granted by Judge Hahn, no, I'm sorry, a month after the final parenting plan was entered by Judge Hahn, or when the accusations start against the respondent in this case. And now we're just hearing about all of these major concerns, which is it's a little concerning. I've read some case law. I've looked at everything here. The final the temporary order allowing the move orders that the final parenting plan is what's followed. I guess I don't see anything that would suggest that there doesn't need to be a finding of adequate cause to make a major change to a parenting plan. So if anybody wants to enlighten me why that isn't the case, other than what you've already provided, I would be very happy to hear about it.
I'm sorry, could you repeat the question? That was sort of in a negative, and I'm trying to figure out what the question was.
I don't know why we wouldn't need adequate cause. So if there's a way around not needing an adequate cause finding to make a major modification to a parenting plan, that's what I want to hear about, other than what you've submitted, because I don't think that question was answered by what was provided.
Well, I guess if I could. Who do you
I
want
think
to
it
hear
may
from
be,
first?
no, I think it may be defers to me, because I believe Ms. McLean's position is going to be, I agree with Your Honor, that adequate cause is needed. If I'm not misstating Ms. McLean, that's what I said. We put in, Your Honor, the authority in the relocation statutes and how you can. The court on that date also, if you look, the minute order did find adequate cause. So I guess it's at this point, a decision I would feel Your Honor has to make. We've provided the statutes and case law that allows you to do so.
Hey, point that out to me specifically.
Yeah, so RCW 2609.260 section 6, the relocating person's proposed revised residential schedule, they may file a petition including a change without a showing of adequate cause to the proposed relocation itself. A hearing to determine adequate cause shall not be required so long as the request of relocation is being pursued. Same thing.
But relocation and a major modification to a parenting plan are not the same thing, are they, Ms. Joslin?
But they're one and the same. Like, she's relocating.
They're not one and the same. I mean, because the parenting plan has been exactly the same for over a year since the order allowing the move has been in place. So they're not one and the same. And she's done nothing in a year on the move to progress to trial. So I guess where I'm at is, why isn't this immediately being set for a trial assignment on the move, a GAL being appointed, and we go that route? Because I guess to me, that'd be the quickest way to get a resolution here. If there's additional, so I disagree with your reading of that statute. What else do you have?
And I think, secondly, we were also going to say we agree with the court. I think a GAL would be appropriate in the matter so they can talk to the kids. Then we have the two cases, the Philpott case and the McDevitt case. I'm terrible, Your Honor, at pronouncing, so I apologize, that allowed the move. Right now, like we have.
I guess I would just interpose an objection to the court's reliance on Philpott. As there's been a violation of GR 14.1A, as counsel's memo did not clearly delineate that as an unpublished opinion as is required. And there's other case law that is published that clearly could be relied upon. She's provided no showing that that's a basis for a need to rely on that unpublished precedent.
Okay.
So we have those. Yeah, I mean, it's what we've shown. I think the biggest issue is that the relocation is still open. It hasn't been decided. There is no permanent. So based on everything that we've provided allows it to modify. Now, if the court doesn't agree, or if the other side didn't agree, we could have simply said, let's set it over. She'll file the petition instead of wasting all of this time and effort back and forth. My client did this in good faith. She wasn't trying to be going behind things or doing anything. Legitimately, based on everything we've read, says she can do it. I understand if the court disagrees, and so then I think we set it. And then if the court wants us to file a petition, okay. If not, we set it for trial, appointed GAL. That's fine as well. And my client didn't just not do anything. She's been trying to work with the other side and just getting pushback or no response. And so finally, she's like, I don't know what else to do but this, because it's increasingly getting worse, just more of like June of this year. So that's why she didn't sit and do nothing. Neither side has pushed this to trial. It's not just her. And so like I said, we have issues. They need to be addressed, whatever manner the court wants to do it, whether they want to set it over. We do a petition, we set it for trial, but we have some immediate concerns that need to be addressed that are coming out through the children's own information. And we have photos that are showing bruises, and like we have issues happening to the children that we need to get addressed. To me, hiding behind like, we should have just said, look, this isn't the way, let's set it over, but that was never addressed. Instead, we had to spend all these times showing what we did, we thought was proper, and now it's just delaying adjudication of issues that need to be dealt with. And we're happy to do whatever the court would like to do. If you want to set it over, we'll file a petition this week. But she legitimately did what she thought she could do.
And I'm not suggesting that she was disingenuous or that it was only the petitioner in this case that wasn't taking action. So I apologize if that's how it came across. There's been no action, period, since that temporary order was entered allowing the move. So that's a little frustrating. Secondly, I never claimed or stated or intended to state that she was being disingenuous and trying to do it this way. I just am questioning whether this is allowed to be done that way. So,
and I think that, yes, I think Ms. McLean says no, and I think that's why we need Your Honor to weigh in. And if the answer is no, how do you want us to handle it? Do you want us to set over, do a petition, which I think would be faster than waiting for a trial date with these concerns? We want to do whatever the court feels is necessary to do.
well, if things aren't getting better, I think both should happen in conjunction. I mean, one isn't,
Okay.
They're not mutually exclusive necessarily, but I can't, the cases that I read, what I was provided, and I'm sorry, I'm taking Ms. McLean's time right now, but I'll give you an opportunity here.
You're
But
fine.
the way I read everything, a major modification, even if there's a relocation pending, requires an adequate cause finding. And I don't see in the order that was entered last September, the temporary order for relocation says anything about an adequate cause finding that this should happen, other than as it relates to the move specifically. I mean, we're not talking about it. I mean, we're Longview to Wahkiakum County. It wasn't like it was from here to, Maine. And it specifically indicates that the agreed final parenting plan from February 1st, 2022 is what will be followed through the pendency of this move and waiting for the hearing about the move, the relocation, excuse me. So that's where all this is coming from. Ms. McLean, I'm sorry if you have any response.
I guess I'm a little frustrated by the court's conclusion that nothing has been done, because behind the scenes, I've been attempting to get this settled and have been put off for the last 7 months, only to be blindsided with this when I was told that counsel was simply too busy to get back to me. So I am frustrated by at least what the court sees in that conclusion. In regards to the court's analysis of the case law and the statute, I think you're absolutely accurate. Counsel's attempting to bootstrap a major modification in a relocation that the court has already granted. The court has already entered the order that has modified the where the visitation exchange location occurs. And I think there was one other small minor issue that the court addressed at temporary orders. This is not, quite frankly, an issue that needs to go to trial. The final parenting plan remains intact. And the basis for Ms. Hansen's request to relocate in the first place indicated on her own relocation notice and on her objection to my client's, and her response to my client's objection to the relocation clearly states in both of those documents that she does not want the parenting plan to be modified. So the suggestion now that we need to have this modification is somewhat frustrating. And my client has done his best efforts to try and provide to the court his counter responses to her false allegations. Obviously, I'm concerned about all of the child hearsay that is clear hearsay in the declarations and the information, and it smacks of Ms. Hansen's history of continuing to expose the children to age-inappropriate communications. You see the Our Family Wizard communications that Mr. Hansen has attached to his reply declarations, showing where he's communicated these issues to her, and there's no response from her. Particularly with regards to the issues on the black eye, where she ran into the back of him because he abruptly turned around to respond to somebody. I mean, these are accidents. This is petty sniping, particularly what the case law that I cited alludes to. And if you go back to the case history, we have an individual who has been evaluated by Dr. Maherg, who had previously engaged in counseling, who clearly, at least from my client's perspective and from the claims, the outlandish claims that are provided in these declarations in support of her claims, that those seem to suggest that she is not mentally healthy right now.
Your Honor, we're going to object. There's nothing before the court that states this. And right now we're just getting to the point of denial of us moving forward. We're not getting into the merits of the case.
I'll note that. Go ahead. Ms.
I'm also concerned about the flagrant violations of, again, like just for example, pattern formed rules. I don't know. I mean, even with my glasses, I had difficulties reading the small font on all of these declarations. Pattern form rules require a minimum of 11-point font. Clearly,
and it is 11-point font.
They don't appear to be 11-point font on my end, and they clearly are different than counsel's font in her own memorandum. That's another concern, just again, in an effort by Ms. Hansen to get additional information in and manipulate those page links. Her late declaration from Ms. Arness, who makes specific allegations about my client before the parenting plan was finalized. My client didn't even date this woman. And he's never had an opportunity to respond to the allegation because that declaration came in after he submitted his reply declarations. So we are very concerned about the declarations and the information that's being provided. It is clearly an effort to try and bootstrap a major modification on a relocation that, again, Ms. Hansen, in and of herself, said the relocation was not a basis to modify the visitation schedule. So at this point, we're asking that the court deny the requested motion. I'm not sure what statute counsel is reading or how she's interpreting it differently, or the case law, because clearly the case law that I cited, even her own case law, says specifically that the basis for the court making major modifications was solely dependent upon the relocation request. But if there are other issues that would be a basis for a major modification, then the petitioning party may file a petition in regards to that. And clearly the statute, RCW 2609-260, requires a motion for adequate cause, because this court is the gatekeeper of whether or not allegations and information arise to a level of adequate cause and whether or not an order to show cause should be entered. And so again, it's very concerning about these procedural deficits. Even when counsel and her client received my client's reply documentation and our memorandum, the response is not to say, okay, we're wrong, we'll do a redo, we'll take this up with the court at a later time and appropriately file. That's not what they do. They forge ahead, and we're here, and my client has expended substantial time and money. The court should make a finding under RCW 2609-260 subparent 11, I think it's 260 subparent 11, about bad faith filings. Again, we do believe that this is in bad faith, her effort to bootstrap all of this information. It's interesting. I guess the other thing that I would point out, at least if you're talking substantively, Ms. Hansen made a call into CPS against my client. It's interesting she didn't make a call into CPS about this cigarette burn, about the bear spray, about these other ongoing incidents. She just makes the one claim, I believe, related to the black eye, to the face slap, where this allegation is a face slap. And you can see my client's Our Family Wizard response to her that says, hey, thanks for calling, that this did not occur, and we really need to be on a concerted front together in regards to our daughter telling lies. And again, if you go back to a parent who has improperly involved children, children are going to see their parents as authority figures. Children are going to say what they think their parents want to hear, potentially what their teachers want to hear, what the police want to hear. And so we've got an individual being one of the children in counseling, and moms using that in an effort to twist that to try and say that it's all dad's fault. That's wrong. It's totally inappropriate. So we do believe that bad faith finding is appropriate and that the court should award my client attorney's fees. I estimate that $3,000 is what we're into already in response to just this motion alone.
Right. Thank you, Ms. Joslin. Anything else?
Yes, Your Honor. I didn't realize that we were going into the whole basis of the motion, so we did not do that on our movie. And I think, as Your Honor was starting to say, she doesn't find our client did this in bad faith. Ms. McLean, unfortunately, seems to think it's only our job to reach out and do something. When she got the moving paper, she certainly could have said, hey, FYI, like, I don't think this is appropriate. Why don't you file a petition and set it? No, instead she takes all of this time and money and decides we're just going to litigate the heck out of this case. My client did this in good faith. She has concerns. The majority of what happened has happened after the relocation. My client calling CPS for the one instance was during a counseling session where the therapist said, call. It's simply because, you know, her client sends one message that says this didn't happen, doesn't mean it didn't. We've shown time after time, his response is, it didn't happen, or kids are a liar. Well, yeah, nobody's going to admit that they hit a kid, let the kid do something, put it pepper spray, all of this. I mean, there's some serious issues if you look just at what the children said. Again, as we have said, we are happy to file a petition. If the court wants to deny it or set it out, we'll file a petition, file the motion in due course, and at the same time, we can note it up for trial. So it's not her waiting, it's her trying to work at it and flinging allegations with no proof about how she's mentally unstable and she's a liar and she's including the kids. There's no proof of any of that. They're just trying to deflect on what the issue is here. And if Ms. McLean doesn't want to get down to the bottom and find out what it is, and I agree with Your Honor, have a GAL appointed and let the GAL investigate what's going on. And so we're happy either way, whether you deny it, we'll set it in due course, or if you want to continue it out for 4 weeks, we'll file everything appropriately and go from there. But she did it in good faith. She has also incurred fees. And so they both incurred fees. I imagine that Ms. McLean really thought her position was correct. We thought ours was correct. They both incurred about the same amount of costs. And they're going to incur more costs, of course, moving forward on another motion or going to trial. So we're asking that the request for fees is denied. And of course, my client is also requesting fees for having to respond to this, which could have simply been resolved.
Okay, thank you. So I'm going to deny the motion. I think it does need to have an adequate cause filed. I have a proposed order on hearing from Ms. McLean that is requesting a judgment of $3,000. I'm not going to impose any attorney's fees in this case. It also outlines that it was in bad faith. I'm not going to make that finding either. So I've struck that, and I've also struck the judgment for fees and costs from sections 1 and 5. But I am denying the motion for temporary orders, given that it's essentially a major modification. I appreciate that if there's safety concerns, then clearly there's ways to accommodate for that. But I don't think that frankly, I don't think a relocate, and I will again apologize to both council if you're working behind the scenes on this. What I see is an order granting relocation, and then, this is the next thing that pops up. So, and I guess I should be more mindful to understand that attorneys do work that isn't just filing paperwork. So, my apologies to both council, with all the efforts you've been trying to get to resolve, or trying to put forth to resolve this behind the scenes. I do appreciate that more than I can express. But I think we're in a position where I would have to make an adequate cause finding. There's no information. That's where we're at. So is it kind of a technicality? Yes. I'm not awarding attorney's fees, and I'm not making a finding of bad faith.
Thank you, Your Honor.
That is ready.
Thank you.
Thank you.
All right. Can you take your hat off, sir? We're in court, even though it doesn't feel like it. I appreciate that. Thank you. All right. All right. We're on for temporary orders. I have reviewed everything that's been filed. Mr. Zandy, you are the moving party if you'd like to start.
Yeah, thank you, Your Honor. That's in fact correct. I do represent the moving party to the motion before you today, namely Gabby Cruz. Here on my client's request as it pertains to a parenting plan, as well as an order of child support for the 5-year-old child that was born as issue of this relationship. I think it's pretty straightforward kind of what's happening here. This is a case where the child's lived with my client for an extended period of time. That dad states in his response that he's had some limited interactions. It's my client's position that it's been exceptionally limited over the course of about 9 or 10 months or so. My client details for you that the last known visit or communication between dad and child was for a brief period of time earlier this summer around Father's Day. That's kind of where we have it. Now, my client initially filed this case pro se, had Mr. Cruz served. He filed a response asking for primary custody, wanted to be designated the primary custodian, did not want to pay child support. That's evident. And that his parenting plan, which was essentially a week on, week off pattern, be adopted. That hasn't been the case for 10 months. And again, his involvement with the child has been fairly limited. My client details for you that basically dad's time is spent with paternal grandparents. Everybody gets along with paternal grandparents. They're good people. And it sounds like they are certainly a good source of extended family for this 5-year-old child. My client is largely agreeable to that. My client details for you, she's largely agreeable to Mr. Cruz having a set visitation schedule. Hopefully he decides that he's going to follow that and exercise his time with his child. But virtually we have very little idea of what's going on in his life right now outside of a new girlfriend who resides in Kelso. And now apparently he claims to be living in a trailer at his mom and dad's house. Regardless, my client needs something put into place. We're proposing that father have every other weekend from Friday evening until Sunday evening. If he chooses to exercise that time with his child, that's fantastic. And if he chooses to allow his parents, delegate his time to his parents, that's certainly probably an option too. Not a lot my client can do about that because, as she states for you, she wants the child to know extended family. We are asking for one provision that restricts the child from being exposed to the paternal uncle, again, whose name is cited in my client's declaration. Regardless, it appears whether it happened or not, the parties agree at this point that there was some kind of a criminal investigation. Didn't receive any information directly from Mr. Cruz related to that. My client has the same concerns today that she had then. This was an exhaustive investigation. And although the court is well aware, even though no criminal charges were brought, it doesn't mean something didn't happen. And again, my client details her concern that a lot of that was based on what prosecutors could prove versus what was unlikely to happen should they pursue the charges against Mr. Cruz. That's where we're at on the parenting plan. As it relates to finances, and again, I think it speaks volumes anytime you get one parent who files a proposed parenting plan requesting a joint custody arrangement and then fails to follow through with absolutely any visitation or any meaningful visitation in the better part of 9 or 10 months. Clearly that looks from a bird's eye view to be financially motivated in nature. We think certainly that applies to Mr. Cruz. He has not offered to pay any form of child support for this 5-year-old and has largely failed anything financially to provide for her whatsoever during the course of the past several months. Taking his own information that he filed in his budget, as well as his financial declaration at the onset of this, it looks like his net income is $3,190. We'll take his word for that. Again, I didn't see anything that came in after the fact confirming that, but for purposes of today, my client's willing to take that as his income. For my client's purposes, she is a server at the Carriage Restaurant in Longview. We have simply imputed her at full-time minimum wage plus tips and given her the income that is reflected in our proposed child support worksheets. If you take that information, you extrapolate that out on a full-time, and I use 35 hours per week, It gives you an appropriate child support transfer, $598 per month owed by dad to my client. We would certainly ask that that be the start date effective of August 1st, which again is close in time to when the motion was filed. And we think that's appropriate. Would also ask that any issues related to back support be reserved in the temporary order, as again, that seems necessary given kind of where we're at. Finally, my client did this as a last resort. She did not have the finances to pay me individually for representation. She borrowed that from, again, her boss at the time. We are asking for a contribution towards her fees and costs. Again, this could have all been probably eliminated in this process, had these parties sat, talked, and discussed outcomes as opposed to just filing a parenting plan for a child you haven't seen in several months, asking for joint custody. Again, that seems grossly inappropriate. We are asking for $2,500 to be paid within a date certain. We've suggested 60 days, but whatever, if any fees the court awards, we would ask for a date certain on those paid directly to my office. Oh, and finally, as it relates to a GAL, I'm not sure we need to go to a GAL at this point. Now, certainly if the parties want to pursue that, they can, but given the fact that Mr. Cruz has had very little involvement, I'm really not certain what a GAL appointment is going to do at this point, outside of just kind of extending the matter and obviously resulting in fees that my client certainly doesn't have.
All right, thank you. Mr. Cruz.
All right, so right off the bat, I apologize. I'm not good, of course, it's my first time ever here. We all have first. I do want to start off with the factor that I do work a lot. I try to be the best person I can be. I've had my parents as I want to say mediator. I don't want to say mediator, that's a big term, but I've had them around to pick her up and a lot of the time drop her off. I work independent shifts, independent jobs. Most of the time I'm up at 5, I'm out of the house, I'm gone, and I don't get home till 7:30, 8 o'clock at night. I work Vancouver, Sandy. I work across, I want to say the state, but I work for Washington and Oregon. My company travels a lot. So I've had them kind of as a middleman to stay in contact with her. I don't want to say I've chosen not to be in contact with her. I guess beginning with that, they've obviously been the middleman. She's kind of dropped off contact with them as the divorce or the temporary parenting plan kind of floated in and kind of just dumped them off. As of, I believe, 2 weeks ago, I kind of became over that. I started working on my bosses and I've had her the past 2 weekends so far, and I'd happily have her more than that. I do live in a trailer. My trailer is paid for. I'd rather live and be able to save to purchase a house down the road. I know times are hard. Working into child support, yes, I'd be more than obliged to pay one. I feel like their number is a little more than outrageous. Last time I looked at it, my wages do defer as well. The numbers I put in, I think was like 33 an hour. I make anywhere between 22 and 50, depending on the job. What else am I at? And then working forward, her uncle, my younger brother. There was, I believe, a case put upon this. It's 90 to 100 days out. I have paperwork. It was closed. There's a lot of accusations put in place for that paperwork. I believe my father put in paperwork as well. That was closed. That was proved false, unworthy of any more lawful time put in. I believe it's false. Honestly, he hangs out with my quote unquote new girlfriend's daughter. We've been together a little over 4.5, 5 years now. He's great with her. He's great with any kid I've had him around. He comes with me everywhere. Further paperwork on that is obviously en route. I'm waiting on CPS, I believe, to get me that paperwork. And moving back to me missing time with her, there's further evidence I need to get into this. She left just before her second birthday, I believe, and she was gone for about 5 years. I do recollect there's a lot in the past. I did note she has a I don't want to call it a drug problem. I don't stay out of her life. I prefer she stays out of mine. And I did request for her follicle test, but I feel like that's out of sorts. Just be the person you're going to be, whatever. I would still prefer one. I know things change. I just as a safety thing. And then I don't know if I can throw this in here for this temporary parenting plan. My aunt, my significant aunt, goes through Mr. Chad as a lawyer attorney. I don't know if that will be a conflict of interest or if that's just going to be passed by and left alone.
All right. Anything else, Mr. Cruz?
I don't think so. I'm honestly, to be honest with you, I'm all over the place right now.
That's okay. I can appreciate you're probably nervous, and if you haven't done this before,
It's
I wouldn't want you to probably see my first appearance in court either. So it's okay. All right, Mr. Zandy, anything else?
No, nothing further, Judge. I think I'll rest on my client's reply declaration and the pleadings.
Okay. So I think clearly a parenting plan, some structure is probably a very good thing for these parties in this case. I did review the information, the financial information. I understand Mr. Cruz's concern with how much I think everything is expensive, and so are children. I will adopt the parenting plan that allows for every other weekend with dad from Friday evening to Sunday evening. And it sounds like there's no concerns with Mr. Cruz's parents being the transporters of the child back and forth, if that works best with everyone. And you said, Mr. Cruz, you've heard the last 2 weekends in a row?
For the last 2 weekends, yes, we have went on. Yeah.
So I don't know, Mr. Zandy, I guess if they're able to communicate to determine if you want this to be back with dad this weekend to start the every other, or if you want, since he had her this last weekend, if you want to go off a weekend, I guess I would defer to the parties there.
I will talk to my client about what her preference is. I'm hopeful that these two can communicate better with each other than they have the last year. So hopefully this will bring them to some kind of a crossroads to do that. So I will talk to her, but I'll work that into the order based on what the conversation is. And obviously Mr. Cruz will get a copy of that.
Okay. And as much as I appreciate wanting to move on and let her have her own life and you have your own life, you have a child together. So that's just not going to happen. So it's better that you learn to at least work with each other. The sooner the better. It's frankly better for your child that way. So I think having a parenting plan in place and that structure is a good place to be. At this point, as far as the uncle, I'm gonna keep the I'm going to reserve on any 191 factors at this point. I will indicate that as part of this parenting plan, there should be no unsupervised contact with the uncle. That can be reviewed, but given the information that I have currently, that may change, but at this point, just no unsupervised contact with that uncle, barring any other restraining orders or protection orders that may be in place. As to the financial information, I'm going to set child support at $598 a month. Starting August 1st, a one-time contribution to attorney's fees in the amount of $1,500 will be authorized, and there'll be a 90-day opportunity to pay that before accruing any interest.
The presentation date, Judge?
Well, unfortunately, my next date, if we want to keep it on a Tuesday, isn't until the 26th. Otherwise, we can do a Friday morning.
I'll be gone on the 26th, but I'll sweet talk hopefully my associate into covering for me if we have to. I'm okay with a Friday as well, but I'm going to run into the same issue. So which do you prefer, Mr. Cruz?
I don't have a preference. I prefer whatever works for you. I'll work around you.
Let's keep that 26th date, not knowing that I may not be present, but Ms. Bliss hopefully will stand in for me if need be. Sir, if you agree to the proposed order, you can just, it's going to reflect what the court said today. You can just sign it and get it back to my office, and we don't have to worry about a court date.
Okay, I can work with that. I can work with what was said today.
Okay. All right.
Thank you.
We'll wait.
Thank you.
And I wanted to confirm that the court received our reply documentation. Mr. Zandy wasn't able to get us his response until quite a bit late, so that put us at a delay. But we didn't want to set this matter over.
Let me see here. When did you send it over, Ms. Baldwin?
I think it came over, honestly, I'm not sure when the hard copy came over. I think that the electronic copy came over very early this morning. Look, there was one, 6:23 this morning.
Okay, I have that. I have not had a chance to review that. Hold on one second. Let me just read the declaration. I'm glancing at the exhibits. Okay, I'm ready.
Very good, thank you. I appreciate the court not setting it over because I think both parties just want to move forward. So again, for the record, I'm Chelsea Baldwin. I represent Matthew Rich. This is our motion for temporary orders. We're asking the court to adopt our parenting plan, child support, maintain possession of current personal property and real property, as well as sort of maintain the debt structure that the parties have engaged in, and additionally award fees to my client. In this case, we have two essentially preschool-aged children. My client was a very involved parent and father during the marriage. Essentially, he worked his work schedule around the mother's. The mother is a registered nurse. She worked some pretty significant grueling hours. When mom was working, he really wouldn't work. When she was home, then he would work. And so they kind of created one of those systems where one person was with the child or the other, but they were both able to work sort of around each other's work schedule. My client says that's what I'm asking to do right now and to maintain. Additionally, my client, as he goes into the winter season, that tends to be the slower season for him. He does essentially excavation and septic work, which there's less of during the winter months. Really, the key question when we're thinking about the parenting plan is, what is in the best interest of these children? Is it to be with a parent, or is it to be in childcare for hours and hours a day, or with a nanny and then childcare for hours and hours a day? Currently, my client has a child on alternating weekends from Friday to Tuesday evening. But what he's asking for is an alternating schedule that directly lines up with mother's work schedule. And that's essentially week one, that the children would be with my client from Friday at 5 to Wednesday morning. And then on the following week, from Sunday at 5 to, again, Wednesday in the morning, which directly aligns with the mother's work schedule. This also aligns these two children's plans with their siblings' plan. So these two children have an older sibling that's under a different parenting plan that would align these two parenting plans together, allow all of the children to have significant time with each other. Again, the concern here is mother works, and again, no, that's not a disparagement. She works a great job. She's a registered nurse. She's very competent. She's a preceptor, but she works 12.5-hour days, not including travel time. So she works from 7 a.m. to 7:30 p.m. That means that she's leaving the house at somewhere around 6:30 in the morning, and she's not getting home until about 8 p.m. Reality is she's leaving the house before these children are up, and she is coming back to the house basically when the children are in bed. And so my client says that system doesn't make any sense. Children should be with me when mom is working those types of hours and be with her when she's not. So again, mother's work schedule is that same alternating structure. So she works the first week, Saturday starting at, again, that 7 a.m. through Tuesday, gets off work at 7:30 and then gets home around 8. And then the next week, she works Monday and Tuesday. So we're asking for the transfer to be on Sunday night, again, from 7 a.m. to 7:30 p.m. My client says that, again, to her credit, when she gets home, especially after working 4 days in a row, she's exhausted. She's worked, 12.5-hour days, 4 days a week. She's wiped out, reasonably so. But that's why he's saying the transfer should happen on Wednesday morning. Mom gets it. Children aren't basically taken out of their beds and given to mom to do this transfer. Children stay in their beds, go to sleep. Mom sleeps. Everybody wakes up the next day. Off they go. Everybody's ready and recharged and ready to have a reasonable day. My client says, hey, I'm fully available. Basically that's what we did during the marriage. That's what works during the marriage. My client doesn't say I've never done anything, during those hours when I could have the children. My client says, no, things do happen, like any parent. He says, when that happens, grandparents step in, and that's not uncommon, that's reasonable, that is a close-knit family tie. This is a family that's very involved with each other. Children spending a couple hours with grandparents periodically is a good thing and not a bad thing. I think sometimes people act like a couple hours with grandparents is terrible, but they're fine to warehouse a kid in daycare for 10 hours a day. Like, that doesn't make a lot of sense. Children should be with grandparents a couple hours periodically. That's good for everyone, including these children. My client details for you, he's very committed to his family. He's very involved locally, has very involved family and extended family, but they're all really close knit. So these children have this very unique bond with both the community that they live in, as well as my client's family that's been part of that community for an extended period of time. Uniquely, you do have a essentially decade-long track record of my client being an amazing co-parent and a 50-50 co-parent. My client's former spouse talks about the fact that they have a week-on, week-off parenting plan with the child of that action, and that's been wildly successful for essentially a decade. That my client's an equal sharer in that relationship, an equal participant, involved in his older daughter's life, participates in her sports, and takes kids to appointments, all of those things. And so you have this track record of someone who's already done this from when that child was very, very young, same age as these children, successfully into sort of the tween years. And so we have a track record, which is something we don't usually have. My client is upset that the children are being essentially, the mom's desires to warehouse them in childcare. That's very expensive. My client says, I don't have those kind of funds to just sort of spend money on childcare, but also that frustration when my client's ready, willing, and able to care for them. The mom just says, no, I'm not going to let you do that. Or as we provide in the documents, when mom puts them in childcare and she's not even working. So again, this significant concern that kids are ending up in daycare when my client wants them, and Mrs. isn't even at work, and they're still ending up in childcare because Mrs. wants that level of control, and that is not reasonable. The current system is essentially mom leaves for work at 6:30, kids are ending up with a nanny, then to daycare, then a nanny, and then mom finally gets home. That's not reasonable. That's an irrational plan that doesn't make any sense. So again, my client says the plan he's offered is very reasonable, not trying to take kids away from mom, but again, putting kids with parents, as that parents should have priority, certainly over childcare. My client does want to get the children involved in the local, where he resides, the local not childcare, the local preschool programs to get, especially the oldest ready. The oldest will start school next year, is the expectation. And so to engage him in that. While I appreciate that Polly's daycare says, oh, gee, we're doing that, I don't think that that's really an appropriate preschool setting. And my client says there's many low to no cost programs available. So again, what's best for these children is solid contact with both parents, not these children ending up in daycare for 12 hours a day. That's not reasonable. Mrs. in her responses then throws out sort of, 191 factors, he drinks alcohol. That's been nowhere for an entire year of this, the entirety of this case pending, that's been nowhere. That's not in her filed proposed parenting plan. That's not in any letter sent. She then just all of a sudden comes out of the gate, well, you can't give him this time because I think he has this problem. But she was willing to, right now they're doing Friday to Tuesday. So there's no mention of that, no concern about that. How could you really be concerned when you're already doing 4 days with that? The reality is you're not concerned. This is just a red herring thrown out there. Second, she says, he makes these terrible jokes. She can find one joke that he posted, I think a year or two ago on a joke website with 170,000 other comments. You have to be digging really deep to try to dig up, some kind of negative something to post about dad in your declaration when that's how kind of to the bottom of the barrel you have to go. So again, this just isn't reality. It doesn't have anything to do with these folks or their kids. This is, again, just a desperate red herring. So you're asking the court to adopt my client's parenting plan to reasonable holiday vacation schedules. But again, that base schedule is based around everyone's working life and the realities of mom's life as an RN. We are asking the court to adopt our child support worksheet. My client's income is based on his actual income. That results in a net income of $5,045. It's based on actual documents that we filed for the court to review. It's not speculation. It's not guesswork. We provided the tax documents. Now, my client is required to, most of the work he does is regarding septic systems. Those are licensed, permitted jobs. This idea that, he takes cash jobs and he's always cheating everything. There really isn't evidence of that. These folks say, he gave us this bid and he made us an offer to pay in cash. And my client explains that, because if they pay me in cash, I don't get cheated at the end of the job. But again, that doesn't prove that he's not paying his taxes. It doesn't prove he's not claiming the income. There's a reality of business expenses, especially when you're dealing with equipment and permitting and licensing. There are expenses there. So just because you get paid on a job doesn't mean that's 100% profit. And I think sometimes folks who aren't running their own business don't quite see that or understand that. As far as Mrs.'s income, she has a gross income of about $13,000 per month and a net income of $9,000, close to $9,500. Again, based on actual documents, her actual wage stubs and tax returns. The difference between Mr. and my client's income as to Mrs. and Mrs. is about $26,000. And that's a big difference in 5 months. So not 26, so that'd be close to $50,000 different in a year. That's a big difference. That difference comes entirely from the shift differentials, all of the extra funds she receives, the overtime work she receives. If you look at her wage stub, yes, her base wage is that top line. And then there's probably about 20 different lines underneath it that are all of the OT, shift differential, proctoring fees, all the different little other incomes that she gets that are all consistent. These are things she receives wage stub after wage stub. There's no indications whatsoever that these are unique. And frankly, these are expected for somebody who is in this career. So again, this is based on her actual income, not sort of what she wants to say she makes. And when you look at the bank statements that we provided, her lifestyle matches it. The bank statement that we provided, shows she pays nothing in housing, no indication she's paying for any bit of daycare costs, no utilities. So oddly, she has none of these expenses. What she does do is go to Breckenridge, Colorado for a lovely resort vacation. So that type of income matches her activity level and what she's doing. So again, my client says, hey, fair is fair. This is my income. This is hers. And she needs to be, her income should be set at the $9,447 that we requested. As to each parent, my client should have a whole family deviation. Mrs. should receive a residential credit for any of her overnights. Mrs. didn't claim that there was any cost as to the child's medical insurance. If they produce one, we're happy to add that in. That's appropriate. She just never provided documentation that would indicate either way. As to property, the folks have already separated their personal property. There's no dispute of who's going to maintain the real property on a temporary basis. That should be maintained, with each party maintaining the debts associated with the property that they've received. Vehicle insurance, each should be paying their own, and I believe are at this time. Medical insurance, Mrs. should maintain insurance for the family. Again, no indication that that costs her anything. So she should continue to cover the children and my client on a temporary basis. As to attorney fees, we're asking the court to award $5,000 in attorney fees to my client. There is a significant disparity in income and also disposable income. So again, Mrs. is a high-level RN. She's a preceptor, which is essentially a supervisor or a training nurse that's training others, or training other nurses that are coming on board. You see significant overtime. She's essentially making double my client's net income. Similarly, again, there's an indication that she's not paying for housing, which she doesn't deny. Her father purchased a home. The indications are he's paying for it. So we provided the assessor's page that shows who owns that home that she's living in. That's her father. No indication she's paying utilities or childcare bills. So again, it's not just that she makes double what my client makes, but also her available disposable income is very high, because there's just no indications that she's paying any of those bills. And that's just a reality for her, which is great. But that's very different than my client's reality, who is paying all of those bills for himself. So with that, we're asking the court to adopt my client's parenting plan, his child support worksheets as proposed, our request regarding insurance and the debts, and award attorney fees.
All right, thank you. Mr. Zandy.
Thank you, Your Honor. As the court's aware, I do represent the petitioner in this matter, Megan Rich, and I can only say that we've been here for now 13 months since these parties have separated, and contrary to the rather convenient comments of Mr. Rich through counsel today, this has never been one where there's been a dispute over the parenting plan or parenting time. In fact, just the opposite. The past 13 months, as evidenced by the pleadings and the declaration of my client has maintained primary care. Both of these boys, Graham is 4, Brooks is 3. So we're talking about 2 very young children who have only known mom as their primary caretaker. Mom has had the kids continuously throughout that period, and Mr. Rich has had every other weekend from Friday to Sunday. That changed in June by agreement of the parties. We extended that to include a 3-day weekend from Thursday to Sunday. So that's where we're at. So again, to make the suggestion that, well, I attempted to get reason with Megan in hopes of getting more time with my children is completely far-fetched to the point of being dishonest. There's never been an issue with that. Rather, the issue for Mr. Rich, the primary motive for Mr. Rich has always been financial. It's always been about that child support. It's always about keeping his stuff. And I'll get to that in a moment. He's paid her $500 a month in child support, despite having the kids for 4 overnights per month. Interesting, there's no allegation that anything is nefarious happening, that anything inappropriate is happening, that my client is anything but a terrific mother, because she is. Again, that's been recognized by the parties. To suggest that Mr. Rich has somehow been this involved father when quite simply he has not, again, is extremely disingenuous to the point of extremely far-fetched. If you look at the history of this, and again, I think this stands out to me. Counsel says, well, he made a couple of off-color jokes. I don't know one single parent, especially one who tries to paint himself in the light that Mr. Rich does, who suggests, again, to an open forum on Facebook. I don't know what joke site it is that the counsel is suggesting, in which they state, which doesn't sound like a joke, baby names you didn't use but almost did. There's no other jokes there. And then Mr. Rich states abort. This then, okay, let's just assume that was a joke. Let's just assume that's off-putting. Let's just assume 99% of the other parents would not think that's funny after having 3 kids. He then goes on, and we provided you messages, which certainly are not off color. They certainly are not meant as jokes, in which he's telling my client, what the F do you think is the matter? When she asks him what's wrong, he states, I didn't want this kid for this reason. This is the same person who's now telling you what an involved, terrific, outstanding father he is, who makes the kids the center of his world. He goes on. Now he cost me, talking about the youngest child, $1,000 a month, and I'm stuck to it. You pay for both kids' daycare from here on out. You wanted them. What does that suggest? That he doesn't care. He didn't want these kids, that they're a burden to him. It goes on. My patience gets less and less by the day. I'm done with screaming kids. I don't want to go to the beach with them. You take the boys elsewhere. I'm so burned out on little kids. He then states again in his declaration, I'm so involved and I'm such a committed father. This is the same committed father who, during his time when my client is working, hires a nanny to come to the house and watch the boys while he's literally in the next room getting drunk with his friends. This is the committed, this is the involved father that he now paints very colorfully in his declaration, that he wants you not to believe that he is. He states most recently, again, that these are not going back far in time. I don't want to deal with the boys. He then pawns them off on grandparents. There is message after message after message in which he's treating these kids as a burden. If you look at his actions, and again, that speaks louder than words, even though Mr. Rich's own words, I would certainly argue, do speak volumes here as to where his heart is. Same individual who delegates all of his parenting time to his parents. I would agree with counsel. Grandparents are great. Having time with grandparents is outstanding. Delegating parental responsibility to grandparents simply because you don't want to pay child support, that's unconscionable. And that's what we have with Mr. Rich. Again, I'm going to use his words. I didn't want this kid for this reason, and then details the cost of that. turns around then brings a nanny into the house to watch the kids while he's home, while he's drinking with friends, while he's out doing whatever it is he's doing, again, on the time that he has. What's my client detail for you? This 4 overnights per month, that was the arrangement. That's what's been in place, largely because of these attitudes, largely because he hasn't had the time, the patience, or the energy to watch these kids, 2 kids who are 4 and 3, full of ambition, full of energy. My client tells you the incident. Again, Mr. Rich makes no response to this, where she comes home after working one of those 12-hour days that counsel points out, comes home and she's got a 2-year-old toddler in his diaper at 8:30 at night in the dark, walking around a dark, cold, empty driveway, just wandering about looking for something to do. Stops, picks up the child, takes him home. What's dad doing? This involved and loving father is inside with buddies getting drunk, didn't even know his 2-year-old had been outside for an extended period of time. As my client details for you, this 2-year-old was pulled to the touch. The same dad whose suggestion in a funny joke was abort. That was the one that he thought was so funny to mention that on the Facebook chat. So again, if we look at the totality of this, that's very concerning. Counsel is also right. No, my client did not initially pursue the 191 factors, in large part because we didn't think that a parenting plan was even going to be an issue. We never assumed that he would come forward and ask for a joint parenting plan when he's done absolutely nothing to pursue that. And again, this has been the status quo for 13 months. There's no dispute from him that my client is the one, if the kids needed to go to the doctor, would take time off, or she would call in sick so that she could take the children to the doctor. Dad's had no part of that. We provided you information from the facility that watches these kids, which does a tremendous job at that, by the way, that says dad very rarely, we very rarely see dad. We either see mom or we see paternal grandparents. And again, because dad delegates all of his responsibility to his folks. His mom is off on Mondays, therefore she's readily available for the kids. Counsel talks about work schedules. Yes, my client works 3/12s. She's a registered nurse and she's doing quality work there in a certainly an honorable field. Dad works 5 or 6 days per week. Dad works out of town. Dad goes extended periods of time where he's not even in town to watch the kids. So here he is suggesting a joint schedule, which this is the first we've heard of this, requesting a joint schedule when he's not even going to be home a majority of the time. These kids are used to the structure. These kids are used to the stability. These kids are used to mom being their primary caretaker. And for dad to now come forward because he doesn't want to give on the child support issue, dad to come forward and say, well, I want a joint parenting plan. Now, therefore, we should get it because I don't have any significant black marks. And even though I drink a little bit too much, it shouldn't get in the way of me not paying child support, because that's what this is all strictly motivated by. We have those issues with that. My client didn't put the 191 factors in because it was only 4 overnights a month. She didn't include those in the alcohol issues because, again, she didn't want to go down this path of litigation. But here we are. So if we look at that, again, dad's response is interesting. He doesn't deny any of the alcohol use. Dad just simply, again, downplays it and says, well, she didn't agree to put that in. Well, no, because initially they had a handshake agreement that he wasn't going to drink during times he had the kids. And my client had some assurance that there was going to be a nanny there because dad allocates all this responsibility to her. The grandparents were going to be there. And we trusted that dad could keep himself together for 2 days while he had the children. I don't know if that's happened or not, but that was the arrangement. Yes, there is an issue. My client has certainly details and parlays that for you in her declaration. We looked at some of the other issues. And again, if we look at this allegation that, well, the older child, again, a child that's not subject to this parenting plan, it worked for her, therefore it should work for everybody. It doesn't gel that way, unfortunately. This child is 14 years old. This child is a teenager on the verge of getting her license. This child is not a 3- and 4-year-old who we've produced information that showed dad's ready to stain for both kids, specifically the youngest one, because he didn't want that child. So again, if we look at that, we're comparing apples to donuts. We don't think that's appropriate. We certainly don't think it's appropriate to say, well, he has a track record with this older child, again, who's a teenager on the verge of high school. Therefore, if it worked with this child, it should work with the younger two. I doubt that dad had the issues with this older child and some of the attitudes he's experiencing and exhibiting with these 2 younger children that he had with the older one. That's first and foremost. Moving forward on the finances. And again, you can kind of see a reoccurring theme. Dad is trying to minimize everything from a financial basis. His easiest way to do that is to suggest a joint parenting plan. If you look at what we provided, again, there's information from not only the daycare, but these random third parties who say, yeah, he did a job for us for $14,000 in cash. That was the arrangement. We paid it. My client details for you that is very common for him. Counsel, and again, is careful in her words. She says, well, the evidence before you shows he makes $80,000. And it does. The tax return, again, certain people, especially those who work on their own business, those are in the contractual field, that's not uncommon for them to fudge their numbers a little bit on the taxes. That's what we have here. Also not uncommon for somebody with an excavator and a license to do that, to go out there and do the cash jobs and to keep that under the table. But let's look at, again, the facts that we have before us. He's suggesting he earns $80,000 a month, or his counsel states $5,000 or $80,000 per year or $5,000 per month. Let's look at the budget he produced us through discovery. He shows a monthly budgetary need of $12,418. It's interesting when you just dissect that. Keep in mind, he's living in a $1 million home on 11 acres in very desirable Kalama, I believe, with a nice view. He's got outbuildings on that. He bought and paid cash without my client even knowing towards the end of the relationship, a vacant piece of land on Mount Pleasant for about $70,000. How does somebody making $5,000 a month do this? He drives a 2017 truck. Again, that's between $40,000 and $60,000. He has all these toys. He's got Can-Ams. He's got, he's got the Kubota tractor. He has significant cash resources that he has at his availability. You look further at that budget. He pays $260 per month for what's called help. That's a maid. I don't think that even includes the nanny that he pays on top of that. Most people making $80,000 per month don't have a nanny and they don't have a maid. They also don't have the luxury of paying $418 a month for television and internet. And again, this is directly from him prior to coming to court. So, there's a ring of truth to it. He's got $1,300 per month for food, $200 for gifts, $250 per month for recreation, $45 a month for club dues, $250 a month for travel, and $200 that is miscellaneous and undefined. That all equates again to this $12,418 per month budget. Interesting when counsel says, well, there's no information that Miss Rich makes a house payment or pays rent or utilities. Well, who's paying it if she's not? Of course she is. And again, I didn't know that was an issue prior to today. That seems like a pretty significant stretch on Mr. Rich's part to allege that. But if we look at this, and again, his comments about, well, this is why I didn't want these kids, is because they cost too much money. You're going to pay the daycare. What does she do? She gladly pays the daycare because that's the type of parent she is. That's an involved parent. That's somebody who wants what's best for their kids. That's somebody who's a provider. That's what she's done. He has not. I think her income is what it is. We provided you the pay stub that shows she makes $51.22 per hour. She works the 312s at 36 hours per week. That puts her gross monthly income at $8,809. To suggest she's making $160,000 in wages as a nurse working 36 hours a week, again, is far-fetched. My suggestion is we simply take her hourly rate, extrapolate that over the 36 hours per work week. That comes up with the number that we have reflected in our child support worksheets. We've also indicated, again, if you take Mr.'s monthly budget, you multiply the $12,418 by 12 months, you're going to come up to a very different number than $80,000. We believe he's making at least $160,000 per year, probably closer to $190,000. We're going to need to do much more discovery on that, get permits, which takes time from the county. And I talked to these various other people that, frankly, we have that are willing to say that he's done cash jobs for them. And we'll get down to the bottom of what it is that's realistic of him making. But again, to suggest $80,000 per year while she's making double that as a nurse is completely disingenuous to the point of being preposterous, quite frankly. That's our suggestion. My client has told you in her declaration that she's primarily concerned with these kids, to uproot them at this age, take them out of the primary home that they've known for the past 13 months. Again, that was uncontested, given dad's issues and given dad's propensities to delegate his parenting authority to others. Again, it's not in the best interest of these children. It's not in the best interest of these children, and counsel states, well, to put them in daycare. Well, sure, but what's dad doing? Dad's pawning them off on a nanny. So again, and he's gone 5 or 6 days a week. So again, that's what it all comes back to simply disrupt the apple cart and say, well, although these kids are doing very well and have been for the past 13 months, let's change that significantly because my 14-year-old daughter from a prior relationship has a different plan. Again, that's not what's best for Graham and Brooks. And the parenting plan that we have suggested is. We're asking you to follow that. If you want to refer this to a guardian ad litem, certainly I think the alcohol issue, certainly I think the work schedule, and certainly I think the use of third parties to watch the kids over dad's time is all fodder for that person to investigate. We're happy to do that. But where we sit right now, there's absolutely no reason to change this. And this is not a joint parenting plan type case. This is a case where these kids should have the stability and consistency that they've enjoyed since these parties separated in July of 2022. Defer on fees. We're not asking for both these people have enough money to pay for their own legal fees.
All right. I'm going to ask counsel to join me in a breakout room for one moment. And Miss Terry, we can go off the record. I'm going to leave the Zoom up and running, but if Miss Baldwin and Mr. Zandy could please join me, I would appreciate that.
You are on record.
Thank you so much. All right. I had a sidebar essentially with counsel, and I've realized after reviewing and hearing some of the information today that I likely have a conflict in this case and I will need to recuse myself. I wanted to relay that to the attorneys and give them an opportunity to kind of weigh in on where and when we put this case for review, because I don't want to set it over unduly long. I am doing, from the looks of it, the pro se dockets Wednesday and Thursday this week, so that wouldn't work. And so we're going to set this matter over to the 13th. I have the order at 9 o'clock a.m. item on the pro se A docket.
I think the only issue I had with that was the fees, depending on whatever Your Honor does with the child support worksheets, and then setting an interim review. Obviously, Your Honor made a temporary ruling as to the schooling, and that was a big concern that my client had and wanted that addressed sooner rather than later. I simply suggested either a 30 or 45 day interim review.
And I don't think every case needs an interim review. I don't think that that's reasonable to the guardian ad litems or frankly necessary in this case. I think the court did what it did as a Band-Aid for temporary orders, but not to then cause these parties to have yet another review in 30 days where there's sort of this idea that we're going to upend the apple cart yet again, type of thing. So I'd ask that we not send an interim review. And as far as the incomes, regardless, Mr. makes 3 times what my client makes. I think the amounts that I sort of just put as placeholders are reasonable. You can always adjust it at final.
Okay. That was under section 6 on the GAL that you were requesting the interim review.
That was section 6.
Okay. First, I did note that the deadline is January 15th, 2023. So did you mean 2024?
I did.
Yes.
Thank you.
Okay. So I'm going to make that change. As to a review date to see about changing schedules, I'm not inclined to do that at this point in time. If there is any concerns or something that arises, then obviously that can be brought before the court. But otherwise, I'm not just going to set a review for school. I think the information that I recall reading thus far is that they're excited, engaged, already enrolled in, or not enrolled, but engaged in extracurricular activities. So I'm going to sign the GAL order as is. Ms. Bliss, are you okay with me saying approved via Zoom?
Yeah, that's fine.
All right. And then as to the order on hearing, there was an objection, or not an objection, a request for non-residential parent having liberal telephone contact under section 4C. Any response, Ms. Baldwin?
Only that this is an interim order and I essentially put kids can call both parents if they wanted it to be her client. I don't think that's a necessary change.
I guess my concern is this order is limiting only the children being able to initiate phone contact. I understand it's only an interim order, and depending on what Your Honor does today, we'll have a formal parenting plan in place. So I'll defer to the court as to that.
Yeah, same.
Okay, so I just added non-residential parent may contact children via phone. I couldn't read my own handwriting for a second. That's not good. Via phone, but shall not unduly interfere with the other parent's time.
Okay.
Then in 4E, temporary possession pending further hearing, and then petitioner shall be permitted to retrieve additional belongings. Any response to that, Ms. Baldwin?
I don't really have any objection. I think everybody understood this was an interim order until we got to today. So
I believe in the your client's response, she indicated as long as there was notice, she was fine with him getting more of his belongings. So
long as he's not just entering the home,
Right.
he needs to make a date and time and arrange for pickup.
okay, so what I've just added, I said Amy Yanez shall have temporary possession of the address. Petitioner shall vacate by that date and time. Petitioner shall be permitted to retrieve additional belongings with notice and at an agreed upon date and time. All right, and I'll sign that. Okay to indicate approved via Zoom, Ms. Bliss?
Yes, Your Honor.
So at this point, and this is my client's motion for temporary orders. This is a 20-year marriage. This is not a short-term marriage. This is a long-term marriage. There are 3 children, all sort of the teenage type ages, from young teens to sort of older teens that we have to deal with as far as parenting plan. My client has been the primary parent of these children. She was the stay-at-home parent for 16 years. The vast majority of these children's lives are with my client being at home, either being a full-time parent at home, or as well as being their educator at home. It's only been in the last few years that the children went into sort of formal schooling. They started through Rivers Christian School, but at that time, my client was also working there. So again, you see that sort of mom and kids are at the same place, the same time. Mom's off in the summer, they're off in the summer. So again, my client sort of sacrificing being the parent that is primarily responsible for them and their needs. And being essentially 100% available to the children at all times. This really only changed in the pandemic. At that point, the children then went from Rivers Christian School to then they transferred to doing some homeschooling. Mr. at that time was doing schooling with them at home, or at least that was the claim. And the concern here, and my client continued to work through Rivers Christian as well as going back to school, trying to sort of get an education so she could better herself reasonably. But when we look at what's happened to children's education for the last 2 years or so with Mr., it's gone terribly. And there's really no other statement here. There's no evidence that Mr. engaged them in required state testing to ensure that they were learning and meeting benchmarks. He doesn't provide any of that to you. So there's the indication is that when it's lacking, it means it didn't happen. He didn't have them tested. And the concern when parents do that is it means they don't want to be tracked. They don't want to have any kind of oversight on what they're doing. So it's not actually doing the job entailed. And how do we know he's not really doing that job as far as educating his children? Well, number one, he's working full time. So this idea that you're going to work full time and teaching is kind of your side gig that you're doing literally on the side of work doesn't make a lot of sense. It just logically is inconsistent. Second, with all the materials, and now he has had extra time to produce them, there is not a shred of evidence he did anything for those years. There's not a single assignment these kids turned in. There is not a single curriculum he produces. There isn't a single test he can show you, not a scribbled notebook sheet of paper. Literally nothing. And that is what is, I think, devastating for these children is they've been unschooled. It's not that he has homeschooled them, he has unschooled them, meaning to essentially strip education away from them. So again, when we have the actual testing, these kids are 5 to 6 years behind now. This is not, not 6 months. This is not sort of the summer leg. This is kids who have actively regressed from their time in formal schooling. And that is a deep concern. And Mr., when you think about his priorities and what he's asking you to do, he wants to return to that. That is his stated plan for these children is I want to keep doing that system, the same system, and keep going to the same co-op that my client says that's really his girlfriend and that's his priority. That is his focus. And that's why he wants to return to there because even though the testing shows this has failed, he just says, I'm going to turn a blind eye to that, blind eye to the objective evidence and continue on because that's what I want. That's what he wants as a person, regardless of whether or not it's harming the children. And so that's the concern is Mr.'s priority is really himself and his desires and not what is best for these with these young children. So again, in a situation where you can't even show a single assignment that these kids have completed essentially in 2 years. So again, priority for Mr. is his desires, not children's best interests. My client also talks about abusive use of conflict, and you really see that with the kids. So your court order last week is kids need to get into school, period, full stop, go get them enrolled. And you see an email from my office to Ms. Melissa's where it's like, man, Mr.'s already interfering. Can you please, we're just trying to get these kids enrolled and get this process going. And Mr.'s already interfering with that. Similarly, it's clear that the children have been made fully aware of the court process and fully, at least as to Mr.'s side, my client's getting the blowback of that emotionally from the children, them being extremely upset, calling my client, they're upset, they're calling her a liar, blaming her for things, because again, what they're hearing is not actually maybe what's the truth about what's happened here, but instead Mr.'s version. And so again, we have this parent who's interfering, who's involving the children directly and trying to sort of twist these children to do what he wants. And so again, a deep concern there. Similarly, my client reports that they had internal security cameras in their home that faced into the home, like the living rooms and those types of places. My client says it's accessible on an app. She knew that. He wasn't going to stop accessing it, so she unplugged all the cameras. Kids going to visit with dad. Magically, all the cameras are plugged back in. My client's like, I didn't do that.
I'm going to have to object. All of this was provided on Mrs. Sir reply, giving my client zero opportunity to address any of these allegations.
Well, I'm not sure what he could address, if anything, on that one, other than he's just going to deny it. But my client, these are objective things.
It'll be noted. It'll all be weighted as well. Okay, go ahead.
So again, the concern here is that Mr. is directly involved in the children, not only in the litigation, but sort of his attempts to continue to surveil my client. Thankfully, the reports are children are doing well at Mark Morris and at TRCS. They have social groups and social outlets already and connections there that they have built through various things. And so they're thankfully getting right back into the swing of things, but it's still going to be a challenge for them. The testing shows they are way behind. And that is going to take some heavy lifting on these children's part to catch up. And the idea that we're going to have some kids that are going through a very challenging time in their lives, and they're also academically going to be really struggling compared to their peers. I think that's something that we need to keep in mind on sort of how Mr. interferes with these children and how that is going to impact, again, their best interests long term. The domestic violence elements in this case shouldn't be ignored. Again, Mr. tracking my client via her cell phone, and the kids' cell phones, the cameras in the home, the financial controls that my client talked about of him sort of providing her an allowance. And there's accounts she didn't even know about or didn't know how to access, and those were his. And she was kind of kept on this really very de minimis budget, all while we don't know where all the money is going, type of a thing. Very concerning. My client points to gaslighting as well as sort of love bombing, that she files this motion and then it's, oh, I want to get back together. Everything's hunky-dory. And again, the culture of these people for 20 plus years is a extremely conservative Christian couple. So again, my client doesn't want to be on this road. So it's sort of that, again, that gaslighting, that control. But the second my client says, no, the kids have to go to real school, I cannot neglect them that way, Mr. blows it all up. And so again, the concern here is that this is not really about, it's about what Mr.'s desires are. It's not about the children's best interests are. But when you look at the parenting plan, so again, my client notes, this is, it's a 20-year relationship. This is long-term. My client notes that she is doing counseling. I think that that's important that she be able to do that to fully understand sort of the elements of the domestic violence relationship she was in and educate herself. I think sometimes people, they see their lives as sort of the norm and don't realize it's not normal, that what's happening is not okay, and not appropriate. And so again, my client's doing what she needs to do to be healthy moving forward. As far as parenting plan, again, my client is not looking to eliminate Mr. This is not a case where my client says, give him nothing, eliminate him from the kids' lives. To the contrary, my client still wants him to be involved. She just wants him to stop involving the kids in the litigation. My client proposed every first, third, and fifth weekend from Friday after school till Monday morning to school. So again, my client says, let's just remove his contact with me and allow him to pick up and drop off at school. And then every Wednesday from after school to pick up or after school till drop off the following morning to school. Again, avoiding my client, allowing healthy contact with Mr. So again, my client is trying to make the right decisions for these kids, even when that's hard, even when that's difficult. And she shows you she does that. She says, kids have done some activities at girlfriend's church. And my client says, that's not my church. I knew what was going on. It was very hard. But I went and I supported them. I went and watched them and celebrated them and didn't sort of put on a sour face about it. I did what was hard because that's what the kids needed. And so again, my client's going to put them first, and she shows that consistently. So again, her focus is kids being safe, them having a home base, and to reduce the conflict that they have to deal with. But to that note, the children should not have contact with Maggie Kennedy. That is Mr.'s girlfriend. He wants to deny that. This is a person who's now showing up, sitting, arm in arm at the kids' volleyball game. To throw that in these teens' faces as they are going through the trauma of their parents' divorce is wholly inappropriate. These kids need a break, and sports should be a safe place, not a place where parents come to gloat, not a place where they're going to bring their new girlfriend or boyfriend and sort of throw that in the kids' faces and make a scene, so to speak. That should be about the kids. And again, that shows Mr.'s focus, that he's willing to do those types of things. And again, these children's culture is a very conservative Christian culture. They need time just without the girlfriend and boyfriend. My client says, hey, Mr.'s going to move on, and that is what it is. But kids don't need to have that thrown in their faces at this early stage in the game. So there shouldn't be contact with Ms. Kennedy. So again, we're asking the court to adopt our parenting plan. It's reasonable, it's thoughtful, it involves both parents. As far as the family home, again, my client is asking to remain in the family home. Home should go with the primary parent. My client thinks that that's reasonable, that's appropriate. My client does not have some kind of magical free housing that exists. That is not a thing. That is ridiculous. It's notable that Mr. is not making the payments. He has still not made the payments. The house is 2 months behind. So essentially, right around the time this stuff is getting filed for temporary orders, all of a sudden Mr. stops paying. And I would again argue that that's strategic because he didn't know if he was going to stay in the family home or not. So he just decided he wouldn't pay the mortgage. My client doesn't have the money to pay it. And so he kind of is having the best of both worlds. If he gets back in, he'll just catch it up. If he doesn't, then he's got this pot of money to go get housing of his own. Both parties should be required to sign I don't know if you call it a loan modification, but essentially their bank has made them an agreement to sort of forgive those payments and tack them on to the end. Both of these parties should sign that documentation and not withhold signature on it. That's ridiculous. My client has bent over backwards to keep them out of default. And both parties should sign those documents to maintain the family asset. Mr. has not been reliably making the payments on the home. So again, he's tarnishing both of their credit as he fails to do that. So there's no indication that he will do that. And that's not reasonable. Mr. should not have access to the home, though, absent agreement. So the idea that he can come and go as he chooses, that should be something that he understands is not happening anymore. That he is not allowed to come into the home, and he's not allowed to use the children as a vehicle to enter the home. As have little Johnny or little Susie, hey, invite me in, because that's, like a free pass. That should also not be something that's permitted. Unless mom says yes, he needs to stay out. Personal items, my client says, hey, we just need to create a date time. She's, again, not withheld a thing that I'm aware of. And so I don't believe that that's really an issue. As to finances. So again, when we look at finances, you have to base finances on the actual documents. And in this case, we have Mr. Through July and 2 days of August making $100,000 and $100,140 is his total income. That is not all of August. It is 2 days of August. So if you then divide that number through 7 versus through 8 months, it makes a big difference because you're essentially cutting out, acting like he didn't get paid for an entire month if you divide it by 8. And that is what Ms. Bliss and her client have done, is they are saying, well, let me claim all of August and basically not get paid and have the court create that false average. So that's where we've provided the math directly for you. It's the 100,140 divided by 7.2. So 7 months through July, 0.2 through the number of days that is appropriate. Do the fraction, and that reaches a gross income of $13,908 gross. Again, no fancy math there. We put it right up front in my client's declaration, so you could do the math if you wanted to. And that's going to leave him a net income, I believe, around $11,000. My client's income, I believe, is undisputed. She has gross income of just over $2,000 per month, net income of $1,768 per month. Child support should be based on those numbers. Really straightforward. As far as spousal support, again, there is a clear and undisputed need. This is a long-term 20-year marriage, very different working circumstances, very different jobs, very different working capabilities and abilities to earn in a 20-year marriage. So this is something that is going to take time, and temporary long-term spousal maintenance is frankly appropriate in a case like this. My client's asking for $2,500 per month in spousal support and child support. With that spousal support,
Say that number again. I'm sorry.
$2,500 in spousal support in addition to guideline support. So the spousal support will be factored into child support, but that is, I'm not asking for that as family support. And here's why. Because of that $2,500 that she's going to receive as spousal support, the mortgage, taxes, and insurance on the home is $2,316. That's what she's going to need to pay. So essentially every month, 98% of the amount that she receives from Mr. is going straight to that mortgage. And so she's really receiving as spousal support really only about $200 for her, and then child support to support the children. So again, very small amount that's really actually going to my client. The reality is it's maintaining and preserving a community asset, which is appropriate in this case. Additionally, the court should award fees in this case. Fees are more than appropriate. I'm asking for $5,000 in attorney's fees. Again, we have a massive disparity in income between these two people. Mr. makes 5 times what my client makes. So it's not even close. And so it's reasonable that he contribute to my client's attorney fees on a temporary basis. As far as vehicles, these folks have quite a few vehicles, and essentially only Mr's is running well. So Mr. drives a 2020 Nissan that runs well. He should be awarded that vehicle along with any accompanying debt. That leaves a Kia, a Suburban, and a Mercedes, none of which run well. The Mercedes apparently is in the shop and needs repairs, and then for additional things on top of that. So my client says none of these things run well, none of them are reliable, and the Mercedes carries debt. My client's request is that the court award all 3 to her, allow her to sell them. Whatever funds she gets from them, she'll satisfy as much of the debt as she can, and then purchase a reliable used vehicle for her and the children. That's reasonable. Again, it's helping the parties get out of debt, gets a reliable vehicle for my client, doesn't take away Mr's sort of daily driver. My client should be ordered to make best payments or best efforts on the payments on those vehicles, again, with the goal being that she's going to sell them and get out from under them. As far as insurance, Mr. should be required to maintain their auto and health insurance. That should be over both the vehicles that currently exist. If my client sells all those vehicles and gets a new one, he should be required to maintain the insurance over that. It's to the party's benefit that my clients sell those vehicles, pay off debt, and purchase something reliable. So again, that's not done as something fun for my client. And I believe there's loans on both the Suburban and the Mercedes. So again, by the time my client pays those debts, there's not a whole lot I'm expecting for her to actually receive from these, but it's better for these parties to eliminate as much debt as possible, and to be in a better position sort of moving forward. So that's a reasonable request. So again, focus here is on the children. Thankfully, in their new schools, they're doing well. They're going to play a lot of catch up. And so we're asking the court to adopt our parenting plan. The goal is to keep these children as happy and healthy as possible. We do want to keep them connected to both parents. My client's parenting plan is a very reasonable one. Her financial requests are also very reasonable. We'd ask Your Honor to adopt them.
All right. Thank you. Ms. Bliss.
Thank you, Your Honor. And as you are aware, I do represent the petitioner and non-moving party, namely Ryan Yanez. Looking first at the parenting plan issue, Your Honor already made a decision as to the homeschooling issue. Despite the fact that my client wished you had ruled otherwise, he's accepting it. He's accepting it until we get more information from the guardian ad litem. Counsel's argument today largely reiterates everything that was said at the last hearing regarding the homeschooling issue, which Your Honor already made a ruling on. So I won't spend time going into that. But what I will say is even in Ms. Yanez's responsive material, she does not deny the fact that my client has played an equal integral role in these children's lives. She did not deny that he assisted her with volleyball, that he's taken them to extracurricular activities, doctor's appointments, dentist appointments. He has been just as involved in their lives as she has. She doesn't deny the fact that he has homeschooled these kids for the last 3 years, that she stepped away from the stay-at-home mom, primary parent role in 2017. So arguably for the last 6 years, these parties have equally co-parented these children. And there's not one shred of evidence before the court that indicates that that shouldn't continue, that these parties both shouldn't play an equal role in these children's lives. Regardless of what Your Honor ruled on with the homeschooling issue, there's nothing that says that my client shouldn't be able to spend the same amount of time as mother, take the children to school, continue to engage with them in church, and the like. While counsel's argument says that it's reasonable that mom isn't trying to take the children away from father, her parenting plan is doing just that. Going from him providing homeschooling and the primary caretaking of these children for the last 3 years to every first, third, and fifth weekend for 3 days, 3 overnights apiece, and 1 overnight visit a week is unconscionable. It's inappropriate, and it is contrary to these children's best interest. What my client is proposing is that both parties maintain their equal role in these children's lives, that they maintain a week-on, week-off schedule. My client doesn't have any objection of transporting the children to and from school. There's been nothing provided that says that he wouldn't be able to do that. Honestly, mother's proposal indicates that he would do that in him dropping off on Mondays and on Thursdays and the like. So mother is consistently bringing up reasons as to why the court shouldn't award my client equal residential time without any shred of evidence. Looking to the allegations of the girlfriend, my client provides the court text messages where mother specifically said, yeah, for lack of better words, I lied about that. I knew that there wasn't an affair between the two of you. I told the congregation and damaged your reputation. She admitted to that. So to continuously come before the court and say, oh, my client's girlfriend is the reason the kids' homeschooling isn't occurring. My client's girlfriend is coming to the games, which again was not provided to the court. There's no shred of evidence that actually occurred except for mom's statements, which is deemed uncredible based on that one text message and that one text message alone. So we asked the court to not consider that. We asked the court to order what is in this children's best interest, which is a 50-50 parenting plan. A week on, week off. There's nothing that says that he is incapable of taking care of these children's basic needs, and that he frankly hasn't done that already for the last arguably 3 to 6 years, that he has been the children's primary teacher and homeschooler while mom was at work during the pandemic. There's a lot of discussions as to domestic violence, gaslighting, and the like. Yeah, there's no 191 factor suggested. Mom's asking the court to reduce father's time based on these allegations, and yet knows there isn't anything to substantiate it into making a 191 finding. There's a lot of discussions of love bombing and gaslighting, but my client tells you he was just as interested in the reconciliation as she was until she hamstringed him and said, I'm still moving forward with my motion. I'm still moving forward with making these requests before the court. You now have less than a week to file a response. So the court absolutely needs to take that behavior into consideration as well, not just admonishing father for whatever actions mother is claiming he made, but also taking mother's actions into consideration as well. What is in these children's best interest is equal time with the parents. I will address the issue of including the children in not age-appropriate conversations or in the litigation. My client vehemently denies any allegation that he's included any of these children in them. However, going from a parent who's been an integral part of these children's lives, homeschooling them and the like, immediately changing it to dad has to move out in 4 days, you're going back to public schools or Three Rivers Christian, there's conversations that need to be had. My client doesn't deny that those conversations happen. He does deny any inappropriate conversations or including them in litigation. These children are having big emotions, naturally. As Baldwin indicated, we're in preteen, teenage years. We have several young ladies in this case, and there are a lot of emotions that these kids have to deal with naturally when they have divorcing parents, but then having this drastic change to their day-to-day activities and their day-to-day lives. Conversations have to happen. My client doesn't disagree with any language being included in a parenting plan moving forward, restricting that kind of discussion with the children. He agrees they shouldn't be involved in it. But unfortunately, things happen, especially in early stages of the litigation. Looking next at access of the home, again, my client's asking the court to allow him to return to the home. He continuously provides for the court that Ms. Yanez has a grandfather with a vacant home. Ms. Yanez has not provided a shred of evidence that doesn't exist. In fact, she doesn't even deny the fact that she did go to her grandfather's house in the early stages of the separation. So to say she should remain in the home, my client should pay all of the community debts, all of the expenses, spousal support, child support, and then go out and get a second home and pay for all of those expenses on what income? And we'll get to that in a minute. But as of right now, Mrs. has the ability to go to this home, hasn't provided anything that says that she can't, despite this being brought up numerous times before the court. And instead says, oh, it's fictitious, it doesn't exist, it's not there. But she also doesn't deny that she stayed there already. So we are asking the court to allow my client to return to the home, ask Mrs. to move to her grandfather's home pending further litigation. Obviously, the court adopts my client's proposed residential schedule. The children will have equal time in both parents' respectable homes, and obviously that's going to be a better situation. My client advised the court that he's currently residing in fellow church members' homes. This is a temporary solution. This isn't a full-time situation. It's not going to be able to house 3 children on a permanent basis. So he is going to have to find alternative housing if Your Honor doesn't allow him to return to the home. And again, with what finances. So let's discuss that. I will discuss my client has provided significant pay stubs, tax returns. He provides to the court that he does work for Nippon as a cybersecurity manager. I agree that counsel's math is similar to mine, but she's neglecting the fact that there's a $15,000 bonus, a one-time bonus that occurs in March, which my client discusses in his declaration. Every March.
Hold on. I can no longer hear you. Wait, say something now, Ms. Bliss.
There we go, just reconnected.
Okay. Every March is the last thing I heard.
Very good.
Do I need to hold that wire?
No, I think maybe it's back on. If it goes off again, it just quit for today, I guess. Okay, so every March, my client provides in his declaration, every March he gets essentially a profit-based bonus based on the prior year's projections and profits. He provides to the court that this happens one time per year. It is not an ongoing, a monthly payment, and the court can see that from the pay stubs provided. It was a one-time $15,000 payment, and that doesn't change. What you do see is he consistently earns roughly $4,400 per month. That is his consistent net take home. So we're asking the court to take his gross income for the year, which is that 101 and change that counsel addressed, less the $15,000 bonus for his monthly income. And that is divided by the 7.5 months, or 7 months, dependent on which pay stub you look at. And that is his monthly income. And that is what the court should take into consideration, not a one-time $15,000 income that happens at the beginning of the year that he's then supposed to address moving forward as if he's actually getting this money, which he's not. So the court can consistently see that he does bring home $4,466 or $76 per month, or twice per month, excuse me. That is very consistent. And that is what we're asking the court to use for basis of child support calculations. This results in I have it as his net income is $8,933.50. We're asking the court to use that for purposes of the child support calculation. Mrs. income is what it is. I understand that there's been a change in her status at the school based on her reply declaration. It doesn't sound like her income has changed. Obviously, that can be readdressed later. At this time, we're asking the court to adopt her income as presented by her. Lastly, my client addresses the fact that he provides for the children and Mrs. medical insurance, and he provides the breakdown as to the costs associated with these. That is $290.34 every single month. So he's asking the court to provide credit for that within the child support worksheets. I do believe that that is appropriate. Granted, whatever monies Mrs. pays for the youngest child's tuition at Three Rivers Christian, she should be applied that credit as well. And lastly, if the court addresses or approves of my parenting plan that my client has proposed, which provides them equal residential time, we are asking the court to award a residential credit. Again, depending on what the court decides to do with the home, spousal support, and the like, all of that needs to be taken into consideration. Again, my client's budget at the beginning of this case shows that nearly 100% of his income and his income alone is dedicated to the community debts. So if Your Honor is going to order that he maintain those debts and award him 50-50 custody of the children, he is asking for residential credit. There just simply is not enough money to go around, despite Ms. Yanez's arguments. So that's what we're asking for the court. As for fees, I understand that there's a disparity of income, except for the fact that my client provides, he simply cannot afford his own fees, let alone Mrs.'s fees. And again, his budget and his actual income are reflective of that.
Does your client, and I don't know I guess I don't know which declaration this came in, or if it was one of the recent ones, any position on the 3 vehicles?
I do believe he addressed that in his last vehicle. It was my understanding that the Suburban was the oldest child's vehicle. But his request for the court was that he maintain the Suburban and the Nissan, which he purchased after the separation, and that Mrs. maintain the Mercedes and the Kia. And whether she sells them and satisfies the debts and purchases a new vehicle, I didn't get his position on that, but I don't imagine that would be an issue.
And so your understanding is that eldest child is using the Suburban, like to get to school and practices and whatnot?
That's my understanding.
Okay. Thank you very much. Ms. Baldwin, anything else?
Yes. First off, just to address that question directly, my client's fine if the Suburban should be awarded essentially for the child to drive. It does have a debt. So essentially it should be labeled as child's going to use it, Mr. pays the debt. We're fine with that car not be sold off so long as Mr. is willing to pay that debt on that vehicle. The Kia and the Mercedes, my client should be awarded and be able to sell those, because the Mercedes has like $1,000 a month payment. It should be sold off as fast as they can with the best efforts towards the debt. Because I'm not sure why the debt on that vehicle is so high, it just is. My client's in favor of appointing the guardian ad litem that's getting on board, so that's good. Again, there is use of conflict. Counsel statement is essentially like, well, gee, things happen. No, they don't. You're a parent. It's ridiculous that a parent would come home, be emotional, and then instead of protect their children from a rough situation, essentially then spill all over them, emote all over them, and try to align them with himself. That is not appropriate. He did not have to tell the children the details of what was happening, the details of the court process, what the parties were taught, what the parties said in their statements and declarations, and then lay blame on one of the parties. That was not helpful to that child. It certainly wasn't. And that's the youngest child. So again, this idea that Mr. can manage himself, he's really not evidencing that, even in the presentation here. The text messages regarding Maggie Kennedy, again, this is an evolving situation where my client had some information at some points in time and more information at later points in time. But there's definitely an inappropriate enmeshed relationship the children need to be segregated from for a period of time. Regardless of what that relationship is, children need to not be in the middle of it at this point in time. So again, my client's not saying forever. She's just saying, let these poor kids heal before they're being sort of shoved into Mr.'s relationships and difficulties. And again, Mr. makes poor choices regarding age appropriate materials. The book that we submitted is grotesque. That is not, it shows people essentially murdering each other in very grotesque ways and advice on how to do so. The idea that you would give that to a young person just isn't appropriate. And sort of indicates sort of, I think Mr.'s, again, what he desires and sort of this need to align. I think that you see parents who do things that are inappropriate with children and allow them to have things they shouldn't have periodically because he's aligning them with himself, because that is satisfying to him. So again, we're asking the court to adopt my client's parenting plan. It is extremely reasonable. It gives kids a home base. It maintains relationships with both parents, and it keeps the parties separate, which I think is appropriate at this point in time to reduce conflict for the children. As to the family home, again, my client indicates I don't have free housing. She's never stayed anywhere overnight in the recent past since they've had these troubles or since the divorce has been filed. So there's not some place she can go. That is not a thing. Mr. has stayed places overnight. He has places available now, and his income indicates he has the ability to purchase and a rental for himself. My client, and that's where the incomes and sort of the part of the breakdown of what each party is receiving is important. So my client would indicate that the bonus is consistent. He gets that every single year. Deducting that is just sort of giving him a freebie that's not based on any evidence. He has nothing from his company saying he doesn't get that. He does not. And while it's in his possession and control, he could have easily have provided, hey, here's last year's W-2 and the W-2 before that showing I didn't get those monies. Didn't do that either. So again, the statement of, oh, gee, I'm not going to get this. My client says no, it gets it every year. So again, when you look at my client's requests, so essentially Mr. has a net of about $11,000. My client has a net of about $1,700 pre-child support, pre-spousal. If you take away from Mr. $2,500 per month in spousal, $1,922 in child support. If you take those away from him, that's going to put him at an income of about $6,500 to $6,600 per month net that he has to live as one person. So again, $6,600, he's got as one person to live on. If you add $2,500 and the $1,922 in child support to my client's income, she has $6,200 per month net for 4 people. So 4 people on $6,200 per month and 1 on $66. So my client's requests are very conservative here, probably too conservative. But again, my client isn't trying to be unreasonable. She's trying to trying to think about both parties moving forward. But so again, my client's requests are very reasonable and trying to take care of the children. If Mr. provides any sort of evidence of the actual breakout for the medical costs, I'm happy to include those in the child support worksheet. Ms. Bliss knows the HR documents that I'd be looking for. Happy to include that per statute. That's fine. And similarly, my client, the credit that she receives for the tuition, that should be included on my client's side of the ledger as well. That's appropriate as indicated by Ms. Bliss. So with that, we are asking the court to adopt our parenting plan, adopt our child support worksheet numbers, the requests for spousal maintenance and child support and attorney's fees, and the division of property as indicated.
This is a difficult case. When you have these longer term marriages, it's always unfortunate, difficult to see, and you really do have to consider the children in this case. There are some, frankly, this is a no fault divorce state, so a lot of the accusations kind of the court isn't as concerned with. There is concern with, involving the children. So that obviously there should be no disparaging comments between any of the parties and the children regarding the other or anything to do with the court case. I will award the Suburban and the Nissan to Mr. Mr. will take over the finances for that. The Kia and Mercedes to mom. Mom is free to, or Mrs. is free to sell those and get rid of the debt there. And that will be something that'll be just logged for as we move forward. And the Suburban, I guess, while dad is taking on that debt, that's, I think it's agreed by the parties that that's a vehicle that's used by the eldest child. And if they're unlike or like any other eldest child, then they're maybe ferrying around the other kids to assist parents, and that's acceptable. And so Suburban will stay. Mr. maintaining insurance is appropriate, and we'll ask him to continue to do that. And I agree there should be if there's a significant cost for that. So himself, Mrs., 3 children, he should be given credit for that as part of any maintenance or support that's ordered. Contact with Miss Kennedy. I understand the concerns that Mrs. has. The only thing that I guess I'm a little bit hesitant about is it sounds as though that there are some, and I could be incorrect, so if I am, please tell me, but the way I read it, it sounds like there are some church-based activities that she's involved in and or leading that the children are participating in that originated prior to this action being started. So I guess I would like her contact limited to those church activities at this point in time. And I'm happy to review that as we move down the line. But at this point, I think just to keep things professional, especially given kind of the history of the parties and the length of the marriage. 20 years is a significant period of time. And I understand mom was at home with the children for 16 approximately of those 20 years, and dad's been kind of more of a at-home primary since right before COVID or COVID, so the last 3-4 years. And that does make it difficult, especially when you're homeschooling. That's a lot of time that mom went back into the workforce and dad kind of took over at home. And going back to that, mom should get credit for the tuition that to offset that as well. So that needs to be factored in. I'm looking at the financial declarations, and there's a lot that's been provided, and I went through a lot of that. What I did notice is that I came up with this. I had $89.32 per month based on standard payments. Doing the math with Miss Baldwin's numbers, yes, and then that clearly includes that bonus that comes once a year. In the records, there's nothing that shows that he doesn't get that every year. If it was a $3,000 bonus, I wouldn't be concerned. A $15,000 bonus it's essentially 2 additional months of pay. So it's a pretty significant bonus, and I do think that should be incorporated into the numbers. That being said, understanding it's an annual one-time thing, I am going to factor that into ultimate number, because it's not getting doled out over the 12 months. It's a one-time thing, but hopefully there's planning and savings and all that good stuff. As to the parenting plan, there are some concerns with just, frankly, that book is a little bit wackadoodle, that's something that would be provided to a teenager. I don't know the interests of these children. I don't know if this came from a particular place. And I do think that parents sometimes step out of their comfort zones in order to align themselves with children and or try to find a common interest. This is a little bit of a concerning one and weird one, but I'm not really basing a whole lot onto that, other than I think that kind of information probably shouldn't be shared with children. Just kind of note. The finances and the parenting plan are so closely combined that it's difficult. I do understand. If we assume dad's income, let's just say it 10 grand a month, that kind of evens out that bonus a little bit, and taking away taxes. Do we, let me see if there's it sounds like Ms. Baldwin's indicating that there are no additional homes for her to reside in. I think I took that into consideration last week when I awarded her the home. I don't have anything to say otherwise, other than she's continually indicated she does not have another home that she can go to. The mortgage is $2,300 approximately is what I have in my numbers. So for dad to maintain that and pay $2,500 in spousal support, and what would ultimately be, I'm going to just guess, I can't remember which sheet I was looking at, but I'm going to say $1,500 in child support. So, and that could be high or low from what we're working on, but that's approximately $6,300 of his take home, and then having to rent a home on his own, where we are depleting the funds pretty significantly there. And I do recognize that. Here's what I'm going to do. So the standard calculation in at least this one that I'm reviewing has child support at $2,800. That's Miss Baldwin's number 2. That doesn't have any, actually I take that out. So the transfer would be after at least some of the credits. Is that correct, Miss Baldwin? 2,800? Am I reading
So
that?
it's 2,800. That gives him that's with my client receiving a small, like a $300 credit for education costs. And I think that's not counting any of the medical costs towards him though. So there's uninsured medical costs that my client was presuming she'd pick up of around $80, but we didn't have any information on the children's portions to include.
Okay. That also is with his wages being set at $15,717 a month. Okay. So I'm gonna you both know that I hate math. I'm going to set his income at 10,000 a month.
Okay.
And so I
Is that
want,
net or gross?
That'd be net.
yes. And then we'll, let's work off of that number. So won't have a final number for you. As far as the parenting plan, there's part of me that completely agrees with Miss Bliss that there's no reason to limit Mr.'s parenting time, and that there is, kind of a want for the court to start at a 50-50 parenting plan. On the other hand, I understand the arguments for every other weekend, Friday to Monday, and Wednesday, every week, Wednesday to Thursday. Here's what I'm going to do. I'm going to do week 1 will be the Wednesday PM to Thursday AM. So, and I say PM, I mean after school. So Wednesday after school to Thursday AM, and then Friday after school to Monday to school. And then week 2, week 1 would be, I'm going to start all over again, and I apologize. I'm going to do Wednesday after school until Sunday for week 1, or excuse me, until Monday at school. And then that week 2 would be just the Wednesday after school until Thursday morning.
Okay.
And then the next week it would be Wednesday until Monday AM. Does that make sense?
Yes.
Miss Bliss, ask a question if you have it. So it would be
I just want to make sure.
Wednesday, week 1. So Wednesday after school until Monday at school.
Right.
And then he would get that Wednesday, just one night. And then it would be 1 week. And then he would get Wednesday through Monday AM again.
Okay. I think I'm following.
And I guess if that Wednesday overnight in the off weeks is better to be a Thursday night, or, based on the kids' schedules, I'm totally okay with you all moving that around. But essentially I don't want more than a week between contact there. So if Thursday works better for schedules, I know Wednesday is an early release at Longview, and that could be the best day. If Thursday night's better, I'm fine with that, or a Friday night. But there would be an overnight and then a longer stint. So that'll obviously factor into child support. So I will defer to the Council on Child Support and running your numbers and your fancy computers program that you have. I discussed the CARS child support. Will kind of need to be rerun based on that. I think we all agree on mom's income, so I'll adopt that as her income, and then giving the credits to both parties. As for the request for spousal maintenance, what I am going to do is I'm going to give, this is a long-term marriage, 20 years. She is working now, wasn't at the time, or excuse me, wasn't for primarily majority of the marriage. I'm going to award some spousal maintenance. So I'm going to award $1,500 a month starting September 1 for 6 months. And then I would like to review at that point in time. As for attorney's fees, there was a request for $5,000 in attorney's fees. Given the discrepancy in finances, I'm going to award $3,000 in attorney's fees to her with a 90-day payment before accruing any interest. And that'll be a one-time only deal.
So
anything I missed?
Okay, a couple
Yes.
questions. So the first question is because Mr.'s housing, so it's my understanding the court's having my client in the primary home or in the family home. Is when does he start his overnights? Because my client's just concerned about he doesn't really have housing. And so she's fine with he has housing, but also doesn't want the kids, we have 3 kids to sort of be flopped on a couch somewhere. So she'd asked us that they be day visits, at least on school nights, until he can get some kind of rational housing. It doesn't have to be perfect, just rational setup.
What's his housing situation?
So, Your Honor, it's my understanding that he's been staying with another couple from the church, and Your Honor had previously ordered that he have overnight visits in the 2 weeks that we've been waiting to come back before the court. So I don't think that that's been an issue. At least it hasn't been brought to my attention that it's been an issue that the kid's sleeping on a couch.
There's a big difference between a weekend and this is like a 60-40 plan. That's a big difference. Kids on the couch on a Friday night is one thing. You got math test in the morning, rolling around in the sleeping bag on the floor is not real reasonable. So again, my client's not saying no to Your Honor's order. She's just saying, can Mr. get some rational housing before the kids are kind of in an unfair spot to them.
Is that, I'm assuming Ms. Bliss, was he awaiting today's hearing to determine whether he was going to look for housing? And I understand that, and that may not be something that can happen super quickly. I get mixed messages about the housing market here, and obviously 3 children is going to impact what he's able to get. A studio apartment, obviously, it's not going to work. I completely and totally understand mom's concerns. I think at this point, I'm just going to stick with my order. If concerns arise, or if there's issues, or if he's choosing to not ever look for housing and just live off the good graces of others, and it becomes an issue, then I'm happy to readdress it. But I'm going to assume that he will make efforts based on the rulings to try to get set up somewhere that will work for them all in a reasonable amount of time. He would have to do that if I adopted his parenting plan. So I'm assuming that since I practically or came close to adopting his plan, that he'll make those efforts. But in the meantime, I think he should get his overnights. Next question.
So the other question that I have is just regarding payment on the mortgage. The court can, and so your honor's ordering a deviation. And it sounds like you're ordering a mathematical deviation based on overnights. My concern is that will, does the court want to look at that at presentation, since we don't really know what those numbers are going to look like? My concern is that the amount orders is not sufficient to meet base household requirements. As far as it's fairly high mortgage for these folks. There's also the vehicle debt that my client's being handed, a pretty significant vehicle debt she has to service until they can get those vehicles sold. And that won't necessarily equate to no payment there either. So my concern is just simply that that's sort of my concern, is we don't have those numbers kind of quite fleshed out to be able to look at what that really means for the parties' incomes.
And I know I kind of went rogue on everyone, and I couldn't even venture to guess what the numbers would work out based on kind of where we went. I'm fine with hearing more about that at presentation.
Okay.
And I'm assuming that's actually a benefit probably to both parties, just because we want to, if it is it appears to be, based on what I've read so far, their largest asset. I'm sure they want to protect that, and for as long as they can. Presentation is, and you may have more questions, but presentation wise, the next court date available is the 26th, or if we don't take a Friday, just so you both are aware.
And I'm okay with the Friday when we get there. But then I do want the court to make an order on the back payments on the mortgage. So if my client's going to pay the mortgage, either Mr. has to catch it up, and that's my purpose, is he has to catch it up because he's withheld the payment for 2 months, or he'd be required to sign the loan documentation, whatever it is that allows. But my client should be in a position where she's paying more than the mortgage previously. That's not reasonable.
And then the other option is the bank is willing to essentially forgive those couple months payments and just tack them to the end of the mortgage. Is that correct?
I think it's either that, or there's a small payment associated with that, where it's kind of like they recalculate your monthly payment. It's one of those two things that results in either a small increase or tacking it to the end. It's one of the two.
Okay, Ms. Bliss, what's your client's position on that?
And frankly, Your Honor, I don't have a position on that. This is the first, counsel's argument was the first I was really hearing that there was that option of tacking on at the end, or, and frankly, that they were 2 months behind. Last I had heard they were only 1 month behind. But nevertheless, I think it's appropriate, obviously, to get the mortgage caught up. I think it's a benefit to both parties moving forward. I would say whatever's the least costly or at least financially burdensome, obviously, is a better option for everybody involved, especially with the fees and everything else that Your Honor has ordered my client to pay, at least at this point. So maybe we revisit that at presentation once we can get a little bit.
I'd like to revisit that. And I know Ms. Bliss doesn't have this information, but they're now 3 months behind because we've now lapped into the next month. And it's a recalculation. So they just add that back into your principal and then recalculate the payment. So that seems reasonable. So I'd ask that he be required to sign it so that they don't just keep digging a deeper hole. And then second, once he signs that, then whenever we set the presentation, he'll be required to sign it like essentially today. We can bring that with the recalculation and the court can consider all of that.
I think that's fair to assume that I didn't look that much into the finances to see like what savings or what any of that entails. And I understand that he's going to have a lot of out of pocket initially. So I think him signing that statement with the bank I say forgive the payments, but essentially roll them into the back end of the mortgage, I think is probably most appropriate. And I will order that he sign off on that as soon as possible.
And then start date for financial orders. We filed in August. I'm asking August 1. Mr. hasn't been paying the mortgage payment, so it's kind of realistically, this, I would argue they financially separated before then. But my documents were filed August 3.
Ms. Bliss, any position?
I believe Your Honor ordered a September 1 start date for at least spousal maintenance. That would be my request, just to keep everything congruent.
That will be the court made an order on the start date. And that puts my client financially quite behind when they've clearly been at financial differences starting in August when she filed and served.
I did say that I did say September. So Ms. Bliss is right on the spousal maintenance. Given the time of filing and everything, I'll switch that. We'll do it August 1. And then that'll put us 1 month sooner for the 6-month review on that.
Taxes. So I would ask, based on where we are, priorities filed jointly for this year, and that any amount received be held in trust until either court division or agreement of the parties.
I don't have any objection to that. I think that's appropriate.
So it'll be so ordered then.
Okay.
It does. I can do the 22nd at 8:45.
Okay, very good.
All right.
Wonderful.
Thank you very much.
Thank you.
Good luck. We can go off the record.